to be August the 11th, Your Honor.
All right, August the 11th. I want to also begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have counsel representing you today, so you should have already spoken to them. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences in your case can and will be used against you. The state is here and they're listening. So follow the lead of your attorney and govern yourselves accordingly. Thank you. All right, deputies, who do we have first?
Just before we get started, so I don't want to have to waste nobody's time. We do have attorneys that are on here for private attorneys. I think Mr. Mike Jacob, your client is not on his counter. I think ASG Evans Bettles will explain why your case is not on the counter today. There's like 4 people
Evans
that are on the
Battle.
counter.
Right, Ms. Evans Battle.
I put a chat into the courtroom too. So I don't want to waste nobody's time. That's, there's like 4 cases. So nobody had to stay online because they're not being accused.
All right. So Cedric Needham.
Is he not on the calendar, Your Honor? I didn't understand because he booked in about 2 o'clock yesterday afternoon. So I thought he might be on this calendar.
We need to ask the state.
Yes, that particular case is not being accused at this particular time. We're getting a felony warrant for his particular case based on the allegations contained in the warrant that we received. So it's not being accused by the state today.
Judge, will he be on first appearance for the felony calendar tomorrow, or when should I?
If that goes through, he will.
Okay.
So who should he check back with, or I don't know.
Yeah, I guess he'll check back with the clerk because they're at the judge's, they're holding with the judge now. So we expect to have the warrant within the next couple of hours.
All right. What
Place him on the
number?
first appearance calendar tomorrow. That would be the plan.
Okay.
And that first appearance felony calendar is earlier, it's before this calendar.
Yes, it's at 11.
Okay, I will check in tomorrow morning at 11.
Thank you.
If you want to check before then, what number can he dial? The general number for the clerk's office? Miss Lewis, what
Yeah,
number?
he'll have to contact Superior Court.
Oh, that's right. Yeah, you'd have to contact the Superior Court clerk. I suggest you do it before 11 because it won't be this Zoom link. It'll be something different. So, around 10 o'clock or that morning, you can check with the clerk of Superior Court to see if it made it on that calendar. Then they will give you the link for the felony first appearance.
Okay, sounds good. Thank you so much.
All right, thank you.
We go to number 10, Mr. Glass.
All right, thank you. This is 26 CR 004983D. Charvis Glass pretrial.
Yes, he has 3 cycles. Last arrest was March of 2024 out of Clayton County for simple battery, criminal trespass, and cruelty. That does appear to be an open case. Level 2 is pretrial's recommendation.
Okay. State.
Yes, ma'am. On July 26th of this year at Mallory Road and Flat Shoals Road in South Fulton, sorry, it's Monday. Good afternoon, by the way.
Good afternoon.
Victim stated she was at a light when the defendant rear-ended her on the driver's side and kept going through the light. The victim was on the phone with a friend, and the friend was coming to check on her, and she saw the vehicle matching the description about half a mile up the road, changing a tire. Officers drove up the road and found the car and the defendant changing the tire, and the defendant admitted that he was involved in the collision, but since he was close to home, he wanted to go ahead and fix his tire. He has a short history, and he has his commercial license was suspended on May 1st of this year. And so we are asking for he already has a $1,500 surety bond set, and we're asking that it remain the same.
All right. And PD Bartels. Oh,
Yes,
okay.
good afternoon, Your Honor. How
Good
are you?
afternoon. Good.
Yes, good. Yes, Judge, I've spoken with Mr. Glass. He doesn't disagree with certain aspects of the warrant. He indicated to me that he did pull over at the earliest safe opportunity. This accident occurred on Flat Shoals Road, which is a very busy area. And he indicated that he did have to drive a short distance before he felt like he could safely put over. Now, having said that, his history is also pretty minimal, and this is a traffic charge. He was born in Riverdale, which I think counts as Metro Atlanta area. So he's been in the Metro Atlanta area all of his life, Judge. He does have family, including both of his parents, aunts and uncles, and his extended family that all live in the Metro Atlanta area. I'm also advised that he has a job. He works at the KFC and Taco Bell on MLK Junior Drive. So, given all of that and the nature of the offenses, we would ask for a signature bond. Or if the court's not inclined to do that, we would ask for a $1,000 bond and nothing further for now.
Okay. All right, I will give him a $1,500 signature bond. That signature bond through pretrial level 2. I will also order that maybe, I don't know if he should be driving, if he has his proper credentials, or no driving unless he has a valid license,
Unless
insurance,
it's
and
legal.
registration. Mhm.
Yes, ma'am. All right. Thank you, Judge.
Oh, and I'm sorry, no drugs, alcohol, weapons, or guns while on bond. The normal. And that's
Thank
it.
you, Your Honor.
All right, thank you.
Good afternoon, Your Honor. Next is
Good
position. Hi. Next is position 5, Miss Doyle.
Okay. This is 26 CR 004977E, Javier Doyle, pretrial.
2 cycles. The last arrest was April of this year out of Clayton County for FTA. Level 1 will be pretrial's recommendation.
Okay. State.
Yes, ma'am. On July 25th of this year at 4300 Flat Shoals Road, Union City in Fulton County, there was a verbal dispute that turned physical because the victim asked the defendant if she was going to go to work. The defendant grabbed the victim's shirt and caused damage to it. There were no physical injuries observed on either party, and the defendant was not there when the police arrived, but officers observed her walking aggressively towards the apartment later. There was a camera in the apartment, but it did not show the physical dispute, and it only recorded the verbal dispute. And the victim did say that the defendant is experiencing postpartum something. It's not clear from the report what exactly she's experiencing postpartum, but she is on medication for some sort of I just lost my words. Some sort of something because of postpartum. We're not sure what though. And I believe he will be on Zoom. So if you don't mind sounding for him, his name is Brandon Henderson. And we are asking for a $3,500 surety, a stay away from 4300 Flat Shoals Road, Union City in Fulton County, and no further contact with Brandon Henderson. And nothing further.
Okay. Brandon Henderson.
Yes, ma'am.
Do you wish to answer a few questions for the court today?
Yes, ma'am.
Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of Miss Doyle?
No.
Do you want to have further contact with Miss Doyle?
Yes.
Do you all reside together?
Yes.
Do you have any children together?
Yes, ma'am.
How many?
1.
Oh, okay. How old?
He's 1 year old, but she has 2 children that I take on as my own as well.
Okay.
So it's 3 in total. So
All right. don't have any other questions at this time. State or PDs, I don't know if anybody else has any questions of you. No.
Nothing from the state, Your Honor.
I just want to say, am I allowed to speak?
A little bit, but this is not the trial. This is the bond hearing. So as long as it doesn't go to generally the allegations, because we're not here for that today. I'm just making sure that she will show back up in court if she gets a bond to get out, or what type of bond to give her.
She will definitely be at court. That's for one. And I just wanted to say the incident was an accidental, it was an accidental confrontation. She didn't mean to rip my shirt, and that's all I wanted to say. It wasn't intentional.
Okay. All right. Thank you. All right. You can mute yourself and continue listening in to hear the ruling. All right. Go ahead, State. I'm sorry.
Well, Your Honor, this is Miss Kim's case from the
Okay.
office. I don't see her logged on. Oh,
There she goes.
Hey, good morning.
I know. I'm not used to seeing you on scene, Mr. Bartell, so I apologize.
Yeah, no problem, Judge.
All right. PD Kim?
Yes, Your Honor, I'm ready.
Okay, hold on one quick second. Attorney
Sure.
Charles Cullen, who do you represent?
Good afternoon, Judge.
Good
I
afternoon.
represent Devin Lumpkin. I was just in another Zoom and was told that that I'd been given the wrong Zoom link.
Oh, okay. We do have Devin Lumpkin. I think he's position 15. So we'll get to you in 1 second, okay?
Thank you, Judge.
Uh-huh. All right, go ahead, PD Kim.
Yes, Your Honor. Miss Doyles is 28 years young, Your Honor. She has been here in Georgia for more than 4 years, and Your Honor, she has 3 minor children right now. After graduating from high school, she has been working as an Uber driver, and she's currently residing with her sister and child's father, who is complaining witness at this point, and 3 minor children. We asked for signature on bond and also no further violent contact.
All right, what I usually like to do is make sure that there's been the ample cooling down period. PD Kim, did you say she works or no? You said Uber driver.
As a Uber driver.
Right. But I want to make sure there has been the proper cooling down. This happened yesterday, give or take, or day before maybe. And the victim is on. Hopefully it is a one and done and they can get it together. So I will give her a $3,500 signature bond through pretrial. And she will be, I think, at a level 1.
Your Honor, she has a 2026 failure to appear.
Okay, in Clayton in April.
I can double check that, but she does have a failure to appear from this
Right.
year.
Oh, I know. It's a parking issue. I don't have a fancy information.
Yeah, figure it out.
Pretrial.
Incident happened Friday, Your Honor.
Victim doesn't need to speak about the defendant's criminal history. Pretrial.
Yes.
You're looking at that 26 FTA in Clayton.
Yes, that's on her GCIC.
It is on her GCIC. Okay.
Yes.
And does it show what the charge was at all? I mean, what the underlying case was, or?
Let me look into that. Give me a second.
Okay.
I have charge description, SUS registration. I'm guessing suspended registration, and it's out of Clayton County. Yes, ma'am.
Okay. So a driving charge.
I don't have her driving history to verify that.
Yeah. Well, I'm saying from what you said, the
Suspended
accidents-
registration.
Right. That's a driving charge. So I'm going to still, unless pretrial tells me something different, I will go ahead with the $3,500 signature bond through pretrial level 1. She is to have no further violent contact with the defendant. No drugs, alcohol, weapons, or guns while on bond. And I'm going to have her to take 6 anger awareness courses through pretrial that are offered for free through pretrial. And I believe that's it.
Thank you, Your Honor.
All right, thank you.
Let's go 15.
Okay.
All right. All right.
26 CR 004961G. Devin Lumpkin. Charged with battery, family violence, 2 counts of battery, family violence, pretrial.
I show this as the first arrest. Level 1 is pretrial's recommendation.
All right. State.
Yes, Your Honor. In this particular case, this happened at 170 Horizon Hill. The victim in the case appears to be the father, Gerard. The mother, Kim, was walking out of the house, indicating that there was a physical altercation, and he had been taking and selling items from the house, and that was using the money to buy a cell phone. Hid the cell phone from his parents. He is 17 years of age. There are other concerns that the family has for him. I think in this particular case, they're on the line. I know that there is, well, she didn't write down how much the bond is currently, but I'd ask for a $4,000 signature bond through pretrial services. That'd be at level 1, that there be a either a BHET or at least some information to confirm his BH issues, whether that's with the social worker or the family during their pretrial services monitoring. No alcohol, drugs, or weapons while out on bond. The parents have spoken with the victim advocate. They want him home. And so the state is not opposed to no further violent contact.
All right. And Attorney Cullen.
Yes, Your Honor. My client is, as stated, a 17-year-old with no criminal history. He does have an autism diagnosis, and this event really arose out of his autism. His parents are the ones who hired me, and they are asking the court to release him into their custody. They're working through this behavioral issue. He's never had an issue like this before. And so I would ask I realize the court can't give an unsecured judicial release on a family violence charge, but I would ask the court to go as close to that as possible. I don't know if the sheriff's 10% program can be used with family violence charges, but the bond will be, paid by the alleged victim here. So I am asking the court to try to make that as easy to do as possible.
All right.
Sure,
And
if you heard
Go
me,
ahead.
I asked for a signature bond. I
She
didn't ask. Okay.
Yeah. The state did ask for a signature bond. So he's still in high school or no?
Yes, Your Honor, and he has an IEP.
All right. Well, I will not order the social worker visit since it seems like the parents are already on top of it. I'm going to order the $4,000 signature bond through pretrial level 1. I'm going to order that he continue with treatment and follow that treatment and any medication that he needs to be on as well. I'm going to order that he have no further violent contact with the victim, his father, and that also no drugs, alcohol, weapons, or guns while on bond. Because of that, I'm not going to order any anger awareness courses. I assume they will handle that with the other treatment or things that he may have. And I think that's it.
Said 4,000, right?
Yes, 2,000 on each. All right,
Thank you,
anything
Judge.
else, council?
No, Your Honor. I appreciate your time.
All right, thank you.
May I be dismissed, Your Honor?
Yes, you may. Thank you.
Thank you.
Next is position 9, Miss Gates.
This is 26 CR 004981D, Maria Gates, pretrial.
Yes, she has a total of 4 cycles. Last arrest was from 2023 for criminal trespass out of Albany. There's no disposition, so the case appears to be open. Level 2 is pretrial's recommendation.
All right. Babe?
I also have an active warrant out of Albany for failure to appear. I'm not sure if that showed up in her history, but I have it in mine. And on July 25th of this year at 1360 Virginia Ave, East Point in Fulton County, the victim, Dante Bowden, stated that defendant would not let him sleep, so he called the police, and while he was calling them, she smacked the phone out of his hand, and officers arrested her for the simple battery of knocking the phone out of his hand and also her active failure to appear, again out of Albany. And our victim should be on the line, so if you don't mind calling for him, Dante Bowden, that would be great. And we're asking for a $5,000 surety bond, $3,500 on the simple battery, and $1,500 on obstruction of a 911 call. A stay away from 1360 Virginia Ave, East Point in Fulton County, and I believe that is a hotel. So I'm not sure where they live because I believe that was the O'Connor Lodge. I'm trying to find it now. 25, 26. Yes, that was the O'Connor Lodge. So I'm not sure what their home address is, but if we could do a stay away, just a general stay away from wherever the victim lives and works, that would be fine with the state. And no further contact with Dante Bowden. And again, he should be on the Zoom. I'm sorry, no further violent contact with Dante Bowden. He is okay with having contact, but no further violent contact.
All right.
And I don't show what the failure to appear is for. I don't know what charge. I'm guessing it's potentially the open criminal trespass, but I don't know that for sure.
All right. The victim, Dante Bolden, not on the line. All right, go ahead, PD Kim.
Yes, Your Honor. Miss Gates is 50 years old, born and raised here in Georgia, Your Honor. She graduated from high school, and she does live with her grandmother, which has a different address. We do have an address at the Odyssey. She has been unemployed for the last 2 months. Because of that, she's financially challenged right now to pay for any kind of bond. We asked for a signature on bond. I believe that she does not have any conviction or felony charges. She's not going to be she's not a flight risk. We asked for a signature on bond through pretrial level 2, and also she may be transferred to Albany for whatever that FTA is. So she's it's not like she's running away from any place, Your Honor. So no further violent contact as well. Thank you.
Okay. This open warrant, I don't know if Albany's coming to get her or not. What is the relationship with the victim and the defendant?
Boyfriend, girlfriend, Your Honor. They do not have any children together. I believe that the hotel is where her boyfriend resides, and she is visiting there often.
And again, this just happened. I don't know that there's been a cooling down period or not.
Yes, ma'am. This just
Um,
happened on July 25th of this year. So
mhm.
approximately 2 days ago.
Well,
More than 24 hours, Your Honor.
well, based on the allegations that we have, I'm going to order the $5,000 surety bond. With that surety bond, 3,500 on simple battery, 1,500 on the obstruction. Oh, well, I'm sorry, obstructing or hindering a person making a 911 call. That would be 1,500, total of 5,000 surety. And I know that the victim stated that he wanted no further violent contact, but I'm not so sure I agree. And they're at this hotel creating this ruckus. So I'm going to ask that she stay away from the hotel for right now. She needs to find somewhere else to go live. I will usually say no further contact, but he said he wants no further violent contact, and state has spoken to him. That's correct.
Yes, ma'am. One of our victim advocates spoke to him earlier today.
Yeah, I don't know if they've had time to really cool it down. I'm going to hold and cool it down for them. She should stay away from Miss O'Connell Lodge's incident location and go stay with her grandmother or whomever else she needs to stay with. I guess I will order no further contact with the victim for right now, even though I know he wants contact. And then they'll just have to ask for a bond modification if things change. No drugs, alcohol, weapons, or guns while on bond. But I think we need to no further contact and stay away for right now.
Thank you, Your Honor.
All right, thank you.
Would you please consider a $5,000 signature on bond, pretrial number 2, level 2, Your Honor? She has no funds to make any kind of bond payment right now.
No, I'm gonna leave it the way it is for now.
At least Sheriff's 10% program, Your Honor.
Yeah, and then that means it comes through pretrial, right?
Correct. You have to set a level on it. You're correct, Judge.
All the 10% doesn't have to go through pretrial.
Does not?
No.
How does that happen, Mr. Jordan? Is he there, Miss Lewis? So do I have to say that on the order?
That's not well, that's my first time hearing that. I guess Ms.
Yeah,
Hutchins
we've
will
never
know.
heard
She
that.
will know because she works in pretrial, so that we were always told that it has to have a level if they go through the 10% program with sheriff. So that's
I
something.
can double check. I don't know if it's, I'm sorry. I can double check. I don't know if it's different from Superior Court and State Court, but in Superior Court, it doesn't have to go through. The 10% option doesn't have to go through pretrial, but I can check if it's a difference.
Well, I'll let her do the 10%, and I think they have her at a level 2. And then usually I was having to say how long. Isn't that correct, Ms. Lewis? 6 months or something? How long the monitoring would be? All right, I guess you're not there. Let's see what pretrial comes back to say.
I was just checking. I'm sorry, Judge. I was talking with Mr. Jordan.
Yes, what does he say?
He has the same knowledge that I had.
Well, let's do that and see what they say going forward from pretrial. She's going to check. Thought that was the understanding. We'll let it come through that.
You're gonna hold for the answer, Judge? And we just move on?
Yeah, let's do that. Let's hold for a second.
We'll just come back.
All right, let's go to 26, Mr. Stevenson.
That's my case, Judge. David Stevenson.
Yes, good afternoon, Mr. Murphy.
Good afternoon, Judge.
26 CR 004987E, David Stevenson, pretrial. Oh, she may not be back.
I'm here. I was on the phone. What was the position, Judge?
26, Stevenson, David Stevenson.
Judge,
Did you find out anything, or are you waiting?
I'm waiting.
Okay.
5 cycles, Last arrest was in 2013 for driving while license suspended or revoked. UJR through the jail was pretrial's recommendation.
All right.
Yes, Judge, there's a consent bond order with the state, and I've consented to it
Okay.
on
Go
behalf.
ahead, Ms. Lewis.
Yes, that's correct. They did send a consent bond order.
Oh, okay. Does the jail know what it is? Somebody just want to put it on the record?
For the consent,
Mm-hmm.
yes, I was trying to get Mr. Murphy's bar number. But for the Stevenson case, it would be a $2,000 signature bond through pretrial services at level 1. It's for willful obstruction, and I'm sorry. Yes, he is to complete the law and decision-making course. No further violent contact with Corporal Foreman of East Point Police Department or any other law enforcement officer. Stay away from the 1337 Virginia Avenue and East Point. No alcohol, drugs, weapons while out on bond. No further violations of the law.
All right.
And if I can get his bar number, I'll put it on here and send it over to the clerk.
Ms. Jevons battled. You wanted me to send it in the chat?
Yes,
Okay.
that'll be great. Thank you.
I'll get right on it.
Okay. Okay. Next.
How was that bond once again? I'm sorry.
Huh?
Were you finished with position 9, Your Honor?
No, we're waiting on an answer.
Okay.
Pretrial.
I'm waiting on an answer too. I've reached out to numerous people to see if they can get back to me first.
Next,
Okay.
next is position 14, Ms. Gilgore.
I think there was a question in reference to position 26. That was a $2,000 SOB through pretrial.
Yes, level 1.
Level 1.
Mm-hmm.
And what position are we doing now?
Position
14.
14.
Thank you.
26 CR 004960G. Adrena Kilgore Mackins. Pretrial.
Yes. I'm showing only one prior arrest from 1998 out of South Carolina for uttering fraud checks. Level 1 would be pretrial's recommendation.
Okay. State.
Estrada.
I'm sorry, Your Honor, I was not aware that this was my case. I believe this is
Kilgore.
Kilgore.
Okay, I'm sorry.
I'm sorry, I was not aware. I was not aware this was my case.
I'll do it. I'll do it. Got it. All right. And for Kilgore, this case happened July the 25th of 2026 at 550 Abernathy Road. There was a domestic dispute at the location in Sandy Springs. The officer met with Aaliyah Earl, who stated that her mother, Ms. Kilgore, had an argument. They were arguing over some family matter. She became infuriated and physically attacked Aaliyah, and that while Aaliyah was lying on the bed holding her child, she approached her, struck her in the chest with her hand, grabbed a hold of her shirt, and began to pull her off the bed. Aaliyah said that she kicked her mother in an attempt to get her back away from her and the child, and stated that she was then grabbed by her arm and again to be pulled off the bed. A male friend who's known as Chris separated the parties in the bedroom. Present in the room also was a 5-year-old, as well as the baby that was in the bed with her as well. And she this case was supposed to have been charged, and I didn't look at as a battery, as a charge as a battery, family violence, and 2 counts of cruelty to children. Is that how it's charged?
No, just simple battery family violence only.
Okay, then it will be amended at some point in time. Then I had asked the prosecutor who was working on the case to do that. But as it is, then what's been accused is for a $2,000 surety. No further contact with Malia Earl, who's the victim listed at this point in time in the case. To complete, the court so allowed for her to complete at least 4 anger management classes. Um, and I believe the victim is on Zoom. I thought I saw her name earlier. Earl. There she goes.
Hi, I'm here.
If the court will sound for her, please.
I
No
can't
alcohol,
see
drugs,
her.
weapons while on bond.
Ms. Earl, do you wish to answer a few questions for the court?
Oh, yes, that's fine.
All right, raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Are you in fear of Miss Kilgore Mackins?
Yes, I am.
Do you want to have any further contact with Miss Kilgore Mackins?
I do not.
Okay. And it's your daughter, right?
Oh, yeah. Well, I'm her daughter, yes.
Oh, the other way around. I'm sorry. Yes, you're her daughter. Is what I meant to say. Thank you. You all don't reside together?
Yes, we do.
Whose name's on the lease?
I'm not sure.
Is your name on the lease?
Oh, no, my name isn't on the lease, but I'm not sure whose name is on the apartment lease.
You said you're not sure whose name is on the apartment lease.
No, you would have to ask her because I don't know if it's in her name or in someone else's name.
Okay. Guess that's all that I have. Anyone else?
Just briefly, Judge, is it who all lives in the household?
It's me, my mom, my baby, and my daughter.
Okay, then.
It
All
is
right.
client's place, Your Honor. She does not want to evict her own daughter and her own grandchildren for her to return home. But at this point, that's what she's gonna be facing if she cannot go back to her own place.
Does she have somewhere else to go stay?
No, my client does not have any other place to go to. This is her place. My client is 51 years old, has been here in Georgia for more than 16 years. She is separated, and she was providing a place for her daughter and grandkids, but now she's gonna have to file eviction against her own daughter. She has an associate degree from South Carolina, and she's currently working as an authenticator for a fashion company. We asked for signature on bond. There was no violence ever, and we asked for go back there until when she moves out or it gets evicted. I want my client to be able to go back home where she pays for all the rent, utilities, all the bills she's been paying for.
Okay. And what was the state's recommendation again?
A $2,000 surety. And I believe the victim has her hand up.
Yes. Miss Earl?
Can you hear me?
Yes, now I can.
Okay. So I spoke with the victim advocate earlier, and as I told her, like, I don't want to hinder my mom from coming to her place. I understand she has to have a place to live, but I do need time to find another apartment. It could be in the next 2 weeks, 3 weeks. I have been looking today. But because I do have an infant, I am in nursery school. I do have a daughter that starts kindergarten, not kindergarten, first grade next week. I would not be able to just kind of like leave the home with two children and a baby that's starting first grade.
Okay. I
And we do
think,
have,
go ahead.
I do have two brothers, Austin Mackins and Potter Mackins. They live in two separate homes. They both have homes that my mother can go to. I was just talking to my brother.
Mhm. Okay, so I'm going to order the $2,000 surety bond.
Your Honor, this is her first single veteran family violence ever, Your Honor. So I think she really deserves to have a signature. She's qualified for a signature on bond through pretrial level 1, Your Honor. No failure to appear
Prior was 98. All right,
Yes.
I'll give her a $2,500 signature bond through pretrial level 1. No drugs, alcohol, weapons, or guns while on bond. I'm going to order no further contact with the victim, Malia Earl, and to stay away from that incident location. No drugs, alcohol, weapons, or guns while on bond.
Can she have a one-time law enforcement officer escorted visit to retrieve her personal belongings? And as soon as she can evict her daughter, can she be able to return home?
I'm not going to advise her what to do about that, but I will allow her one-time law enforcement escort back to the property to get her personal belongings.
And when she's not there anymore, can she return home?
If she's already moved when she goes for that one-time visit,
Yes.
if she's already moved, then she can stay there. Anything else? Don't think so. Is that it, PD Kim?
Yes, Your Honor. Thank you very much.
All right, thank you.
All right, next we got number 12, Ms. Johnson.
(26 CR 004958A Alexia Johnson. Retrial.
3 cycles. Last arrest was from March of this year out of Riverdale for battery. That case does appear to be open. Level 2 would be pretrial's recommendation.
Okay. Date.
Yes, ma'am. On July 26th of this year, Officer Dunbar was flagged down by a female passerby who reported that she had observed an unconscious female lying in a parking garage. Upon arriving to the first level of the garage, the officer observed an unresponsive black female lying on the ground. They approached the female, who was later identified as Alexia Johnson, and attempted to wake her. After several attempts, she regained consciousness but appeared highly disoriented. She was unable to state her location and explain how she arrived there. Due to her condition, she was transported to the hospital for evaluation. While EMS personnel attempted to secure her on the stretcher, she became extremely irritable and repeatedly attempted to remove the safety restraints. After she was placed inside the ambulance, she continued to actively resist restraint. Additional officers responded to assist, and they physically restrained her by holding her arms to allow Grady EMS personnel to safely administer medication. During the struggle, Miss Johnson intentionally gathered saliva in her mouth and spat into the face and hair of the victim, Romina Gotby. So, due to her history and her open battery family violence, we're asking for a $1,000 surety, no further contact with the victim, EMT Romina Gotby, MHET, and possibly a social worker visit for MHET. And I don't see anything about housing. I'm not sure about our housing situation. And the victim's name is Romini Gottby. And if we can sound for her, that would be great.
All right. Is the victim in this case, is it Miss Gossie?
Yes.
Gottby.
Oh, Godby. Okay. Go ahead. Oh, there she is. Do you wish to answer a few questions, Miss Godby?
Yes.
Are you driving?
I'm parked now.
All right, you need to put on a top or a jacket. No tank tops for court.
Sorry. I was just notified this morning.
All right, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes.
All right, put your hand down for me. Are you in fear of Miss Alexia Johnson?
Not at this moment.
Okay, do you want to have any further contact with her?
As a provider, as a first responder, I would have to do my job if I happen to have her as my patient again, because that's my duty. But I will not have any other contact with her.
All right. When you're a first responder.
Yeah, I was the EMT responding to Miss Johnson that night.
Okay. All right. Thank you. Any other questions from the state or PD Kim?
Nothing from the state, Your Honor.
All right. Thank you for coming on. You can continue listening in till I give my ruling. All right. Go ahead, PD Kim.
Yes, Miss Johnson is 25 years young. She has been here in Georgia for more than 16 years. She does have a 4 years old and 2 years old, little young toddlers living with her right now. She doesn't get any child support from their daddies, so she is basically relying on her father, her own father, daddy's grandparent to take care of them. She graduated from high school, and right now she is a full-time student at Georgia State University for nursing school, and she wants to actually graduate and be a nurse. Your Honor, as we all heard, she was unconscious and she didn't even realize that what was going on. She was reacting out of panic. It was something that she had no intention, even though the warrant may say intentionally, she had no intention, Your Honor. She denies that part. And when she found out that that was something that she did, she was very remorseful. She was kind of like shocked by her own self as well. We asked for signature on bond, Your Honor, and also we do have a housing for her. She resides with her father at the address that we have at the Odyssey, and no further violent contact, just in case she may have to be for emergency contact, Your Honor. But other than that, she does not have any plan to have any contact with her.
Okay. And was this a preset bond or no?
There was no set bond.
All right, I ordered the $1,500 signature bond. And trying to see, that one is not restricted, so through the jail. And right now, I think I'm going to obviously order no further contact with the victim. And hopefully they won't have to meet out in the world per se again. No drugs, alcohol, weapons, or guns while on bond. And I guess there's no real stay away location per se.
No, Your Honor. But
Right.
she has
The
no
parking lot.
Your Honor, she has no control over who's going to be at the emergency first responder. So I think for emergency situation, she should be able to have some kind of contact to get help.
Yeah. So just no further contact, no further violent contact with the victim if she's receiving services.
Thank you, Your Honor.
All right.
Thank you, Judge.
Mm-hmm.
Next is position 28, Ms. Thomas.
Pretrial, do you have an answer yet?
Oh, yes, I sent you a message. And
Let's see.
Howard and Bostic both told me the same thing. It doesn't have to go through pretrial.
Oh,
If the 10%.
oh, did you hear that, Mr. Jordan?
Yeah, we finally, we heard back through pretrial, they emailed us, so if you're gonna award a 10%, you have to indicate if it's gonna go through pretrial what level or going through the jail.
All right, so that was on, was it position 9?
Yes,
Maria Gates.
yes.
Okay. I'll just on that one, I'll have it to go through the jail. That's the one with the open warrant. She may be going to Albany anyway.
Yes, Your Honor.
Okay. So that one will take through the jail.
Thank you.
All right, thank you.
So Your Honor, that's will be 5,000 jail, SOB jail.
Either or. She said 5,000 surety or through the 10% program through the jail.
Right.
Okay. All
Thank
right,
you.
the last one is position 28.
Okay. This is 26 CR 004989A, Shanika Thomas, pretrial.
7 cycles. Last arrest was May 25th of this year for simple assault. That is an open case, 26 CR 003385A. That is a pretrial case. We will surrender that bond. A 2015 conviction, disorderly conduct and criminal trespass, and then a 2018 conviction, disorderly conduct. Level 3 is pretrial's recommendation.
Okay.
Excuse me, but what position is this?
28,
Thank
Shanika
you.
Thomas.
Yes, Your Honor, this happened July the 24th at the Village Thrift Store, which is a cooling center in Atlanta, which is located at 1899 Metropolitan Parkway Southwest. The victim in the case is DeAnthony Farrell. He is a security personnel at the location. She hit him with a bag of chips and threw chips at him. She was screaming, yelling, threatening staff inside of the facility. Once the officers went to arrest her, she wouldn't follow commands, resisted arrest, tensed up her body, and start pulling away from Officer Gross from the Atlanta Police Department. The bond is set as $1,000. Surety, the state would ask that it remain the same in light of the $4,000 pretrial bond that'll be surrendered. No alcohol, drugs, and weapons while out on bond. Stay away from the 1899 Metropolitan Parkway Southwest location. Thank you.
Can you give me the recommended bond amounts again?
It is 1,000 surety.
For the simple assault and the
Your
obstruction?
Honor, for each of those, I apologize.
Oh, okay, total of 2. Okay. All right. PD Kim?
Yes, Your Honor. Ms. Thomas, you have a right to remain silent. Please let me represent you and take care of your case. Ms. Thomas is 50 years old, born and raised here in Georgia, Your Honor. She does have 2 adult children. She does not have any grandchildren yet. And Your Honor, my client has a master's degree. Actually, she is licensed as a teacher, and she just had an interview, and she is looking forward to get this teaching job because that will help her to get her feet again 2024, because of a domestic violence situation, she has been at a shelter to protect the victim of domestic violence. And because of that, that's why there is another case, and she is basically going through a very hard time. Being a victim of domestic violence is a very challenging and scary thing. And Your Honor, I believe because of that, she couldn't get the mail. So there's a hold in Atlanta for failure to appear, and they want her. So most likely she will have to go back there. So I asked for a signature on bond through jail so she can be transferred to Atlanta Municipal Court to take care of the matter there. We asked for a signature on bond through jail. Thank you.
All right. I
Or
will.
Your Honor, she denies the allegation. She believes that they had a wrong person. Another lady was doing all that. My client didn't even have a backup chips or whatever that was.
All right. I'm gonna give her the $2,000 surety bond with the history. And that's 1,000 on each surety. No drugs, alcohol, weapons, or guns while on bond. And to stay away from the village thrift store and no further contact with the victim there. Just don't go back there. And I think that's it. No drugs, alcohol, weapons, or guns. Yeah. Anything else?
Not from the state, Your Honor.
All right.
Your Honor, may I please speak?
Who's speaking?
Shanika Thomas.
And you are?
I'm the one being charged. I don't know. I know I had a
Hold
lot
on
of
a second. Hold on a second. Your attorney, it's PD Kim. And I know what she's going to tell you.
Are you waiving your right to remain silent?
Yes, I am.
Very briefly, this is not your trial.
I understand that. But my thing is this, I'm an educator and I don't have any reason to lie. I don't even know what this thrift store is. I didn't have any money to even purchase anything. That was not me. It said I identified female. I don't even know what a thrift store is at. I'm not from that area. I was at a shelter in that area on Metropolitan Parkway. I haven't been to, I don't even know where it is. That was not me. I'm being falsely accused of something that I did not do. And I just interviewed Thursday for a pre-K position. I've been teaching over 20 years and I was about to have this job. Now I'm not going to have it. I don't have any income, any money to pay anything. So I guess I just sit in jail for something that I did not do.
Well, they said that you hit the officer with a bag of chips and
What officer? Just a bag of chips. I have not had a bag of chips. Listen to what you just said. Officer, I was married to a state trooper. I know the law. Why would I even do that? For what? I don't even know what. I don't have any money to buy any chip. What kind of chips? That's why I'm telling you, it was not me. It was somebody else, not me. Maybe they look like me, but it was not me. All black
Where
people.
were you arrested? Where were you arrested?
At the shelter. They came to the shelter. I was at the shelter. That's why I'm saying I don't get it. I don't know. I was at the shelter, ma'am.
Right. Well, I don't know if I can make an informed decision because I don't have all of the, facts and allegations. It's past probable cause. So it was looked at even before I received it. Okay. And I understand.
Okay, and another thing, may I say this, Your Honor? May I please say this?
Okay.
For that May arrest or whatever, I was already, which that is going to be taken care of too, because I know it has nothing to do with this. So I was reporting like I'm supposed to. Every Thursday, the second Thursday, I go to the office. Every fourth Thursday, I report online. Why, again, make this make sense? Where I know that, where I jeopardize it, when I know I'm already on a signature bond, and I would not want that to be surrendered. So again, that doesn't make any sense. Why would I? It was not me. I would, and I just interviewed for a job, trying to move forward with my life. Yes, I've been in a domestic violence situation, and it has been hard. But I'm trying to move forward. But it's like every time I try to take a step forward, I get knocked back. That was not me. Simple as that. And again, I would not jeopardize even that signature bond when I've been reporting like I'm supposed to. Why?
Pretrial, do you all have anything on? I understand and I hear you loud and clear. But we would not be here if everybody did what they were supposed to do and went by their rules and by their bonds. Not saying that you didn't, but that doesn't move me to say I wouldn't do it. We didn't think the other persons that we've done it would do it
Now, I
either.
don't know
And I
where this
get it.
store. I have not been in a store. That's what I'm telling you. I have not
I
been in
know.
a. I don't know where it is.
But they're going to surrender that bond. Pretrial, has she been reporting? But you weren't supposed to get any other charges. I guess they could back off of it if
But
they find out that you didn't do it and it gets dismissed. But that has to come at a different forum and not through this. Do you have any other additional information pretrial?
We surrendered the bond based off the new arrest.
Right.
I can
This is
look into
based off the new arrest.
if you would like me to look into the system, I can, but
But I know you all kind of don't are not moved by the fact that they kept reporting. It's just they shouldn't get into any more trouble. And I get it. So don't
well, let me ask you
yourself
this:
like
does
that.
a thrift store have a camera to show the person? They ought to have a camera in there.
It's she keeps saying the thrift store. I believe that location of the cooling center is in that shop, is in that shopping plaza, and it used to be the value, it might be referred to that as that location. But it is the cooling center, is the location. The security officer was at the cooling center. The officer was at the, who arrested you was at the cooling center working like his part-time job. So that address that I gave is the cooling center in which you spoke of, that you were being arrested at, and that is the incident location. So, I don't have any way today to say whether that was you or not, but the officer and the victim identified you as the person at the time.
So I'm gonna have to leave it at the surety bond for now and continue talking to your attorney to see what else can be done with the surety bond, the $2,000 surety bond, 1,000 on each. And of course, stay away from the thrift shop and
Not the thrift shop, Judge, it's the cooling center.
or cooling center rather. No drugs, alcohol, weapons, or guns on while on bond. And sorry that I can't do more at this juncture for your case. All right. Thank you.
All right, 16, Ms. Maddox.
This is 26 CR 004962J Tiffany Maddox pretrial.
6 cycles. Last arrest was March of this year out of DeKalb County for a probation violation. Has a criminal trespass conviction in 2018 and 2024, and appears to have an open case out of DeKalb for cruelty in the first and terroristic threats. Level 3 will be pretrial's recommendation.
Okay. State.
Yes, ma'am. On July 26th of this year, officers were dispatched to 3301 North Camp Creek Parkway, Southwest, apartment C4, in response to a 911 call from one caller requesting to have a black female wearing a purple shirt and shorts and having a blonde wig removed from the property. The caller stated that the female, later identified as Tiffany Maddox, damaged his back porch window and was still on scene. Upon arrival, they observed the suspect on scene matching the description. She was immediately detained, And the caller stated that she is the mother of his children, and today she arrived at the location irate and ultimately threw a bottle at his window. Both parties do not live together. When the children they share were not on scene during the incident. The victim stated that, I'm sorry, the defendant stated that he did wish to press charges, and she already has a $1,000 surety bond already set, and so we would ask that it remains the same and no further violent contact, or no further violent contact with the victim. I know they share children, so I know they will have to have some sort of contact, so no further violent contact, and stay away from the location at 3301 North Camp Creek Parkway Southwest. And I'm not sure where that is at. I don't have a location here, but I can get that either Atlanta or whatever. But the address is 3301 North Camp Creek Parkway Southwest. And nothing
All right.
further.
Okay. PD Kim.
Yes, Your Honor. Alleged victim is a father of her 3 children, Your Honor, and my client is 28 years old, born and raised here in Georgia. She has 4 minor children, and they reside with their daddies. My high school graduation, and after graduating from high school, she went to university for a little bit of study. However, at this point, she is currently not employed. She does not have any funds to pay for her bond. Indeed, she has been residentially challenged ever since March 2026. After the arrest, I think she has been homeless. We asked for a signature on bond through a pretrial level 3 and no further violent contact. Thank you.
Okay. I'm going to think I will go stay with the $1,000 surety bond. Stay away from that location on Camp Creek Parkway, and no drugs, alcohol, weapons, or guns while on bond. So stay away and no further contact, I guess. Anything else?
Nothing from the state, Your Honor. Nothing from the state, Your Honor.
For her contact with her children, in case she have a third-party transfer, she can not contact Mr. Mitchell Purdue directly, but maybe her friend can contact him, so that way she has some time with her children.
What did you say, PD Kim?
Third-party transfer for children, Your Honor.
If there's visitation, yes, it must be by. Because what did I say? No further contact?
Yes.
Okay, so third-party transfer if it's allowed. And I think that's it.
Thanks, Your Honor.
Thank you.
All right, we got 24, Ms. Sawyer.
Which one?
24.
Oh. 26 CR 004982E, Nayana Sawyer, pretrial.
12 cycles. Last arrest was from 2023 out of Coweta County for a probation violation. Appears to be on probation for possession of meth. That disposition was April of 2025, 3 years probation. That's Henry County, and then appears to be on probation out of Coweta County for theft by shoplifting. Disposition was in 2022, 10-year sentence. Theft by shoplifting convictions, 2018 and 2017. And then a 2019 conviction out of Alabama for theft of property. Level 2 would be pretrial's recommendation.
Your Honor, this happened May the 12th of 2026 at 4894 Old National Highway in College Park. Mr. Kenneth Perry was at the Dollar General and laid his phone on a shelf in the store. And employees saw that he had left his phone, well, saw a phone and took the phone to the front. Apparently, Miss Sawyer saw that this had occurred. Then she paid for her items, went out of the store, came back in and said, and claimed the phone as hers, as having been lost. Mr. Perry came in right behind her and asked for the phone, and they said that someone else had come in and claimed it. They were able to show in a store video and track the phone. So at this time, the bond recommendation, the bond is already set at $2,500 surety, and we would just ask that it remain the same. I'm not sure if Mr. Perry is on the call or not. I don't see him there. But no alcohol, drugs, or weapons while out on bond is our recommendation. Stay away from that Dollar General store at 4894 Old National Highway in College Park. Thank you.
Mm-hmm. All right. You can, or Murphy, which one?
Oh, this is my client, Your Honor.
Oh,
Miss
okay.
Sawyer is 28 years young, Your Honor, born and raised here in Georgia. She has 4 minor children that she is currently taking care of. She is residing with her mother at the address that we have at the Odyssey system. After graduating from high school, she was working as a certified nursing assistant. However, she lost her job about 3 months ago. And right now she's trying to get dental hygienist certification so she can continue to get a job. We asked for signature on bond through jail, Your Honor. And she has no objection to no contact and stay away.
All right. The 2,500 surety bond, I'll leave it where it is. Stay away from the incident location. No further contact with the victims, or no further violent contact with the victims. And no drugs, alcohol, weapons, or guns while on bond. 2,500 surety.
Can she have a enlist sheriff's 10% program, Your Honor? She has no funds to pay for the bond, and she does not mind having no contact with a complaining witness.
Right. She's got 12 cycles. And this happened at the refresh me. Happened where?
Dollar General, Your Honor.
Yeah, people need to go in there and be safe and not have all kind of stuff happening with these Dollar Tree, Dollar General, Walmart. So people are wreaking havoc in there in these various stores. So we need to make sure people understand that. She's got the probation cases, and make sure that she will come back. So I'm going to leave it right now at the 2,500 surety.
All right, that's got 29, Mr. Trujillo.
Thanks, Your Honor.
Right, thank you.
Judge,
Yes.
Judge, I had 2 other cases on the calendar, and the jail had advised me that we were going to need resets for them.
Okay, which 2 are those?
The first one is Jamar Coles, Jemar. The jail said that he would not come out for the Zoom.
Okay.
And then the
That's
second,
position, hold on. That's position 3 is going to be reset to Wednesday.
okay, I noted.
Mm-hmm.
And then, Judge, the other one I was appointed on Saturday, Janaid Perkins, and I think she's like in med. If we can reset to
Okay.
Wednesday.
Let's see. Perkins. That is number 22. And that will be reset to Wednesday.
Okay, that's all I have, Judge.
Okay, thank you. See you next time.
Thank you, Judge.
All right, you're welcome.
Thank you, Miss Evans Battle. Appreciate it.
All right. And now let's come back to, I forgot that fast.
29.
Thank you. Twenty-six CR 004992F, Mariah Trujillo. Pretrial.
3 cycles. Last arrest was in 2025, August of 2025 for criminal trespass. There's no disposition, so it appears to be open. Level 2 is pretrial's recommendation.
All right. State.
Yes, Your Honor. This happened July the 25th of 2026 at 1073 Center Street Northwest. The victim of the case is Derek Holliman, Halliman. And this was witnessed by Deneen Holliman. It appears that the defendant bit him on the thumb. She did admit to biting him. He indicated that he was confronting her on the property. He had previously told her not to come onto the property because she will come and use the bathroom on the property. He showed the officer a photographic picture of her squatting in which she appeared to be urinating on his property. I know that, she might tell a different version of events, but once the witness came out, she saw they were engaged in a physical altercation on the ground. As a result of it, he was injured. We are asking for, the bond is set as a $2,000 surety. We are asking that it remain the same. We're asking for no further contact with the victims, the Holliman family, and to stay away from that 1073 Center Street Northwest location, no alcohol, drugs, or weapons while out on bond. And if the victims don't know whether or not they will be on the call or not, at this point, if the court can sound for them, just in case they are, that would be our bond recommendation.
All right. And how much again?
It's for the $2,000 surety, as I already said.
Okay, preset. Thank you. All right. PD Kim?
Yes, Your Honor. My client is actually a victim of this case. Her jaw is broken, Your Honor. She was beaten up to the point that her head she had to have a staples on her head. It was a serious injury that she had to go through. And I think this is aggravated assault or aggravated battery against Mr. Derek Holliman. And Your Honor, the wife here, she is biased as a witness. I cannot find her as a credible witness at all. She is basically hostile to my client, and my client needs to have a fair chance. And she's the one who has to file the police report against him so she can be protected. She is currently residing at Atlanta Mission, the sister's house. It's a shelter for homelessness, and she's been there until probably she has to find a job. She is actively looking for a job. She has a master's degree for Chinese medicine. Your Honor, we ask for a signature on bond through pretrial, no matter what level it is. She has no funds to pay for any kind of bond at this point. And also, she does have 3 minor children that she wants to have a continuous relationships. We ask for a signature on bond and no contact, totally fine with her. Indeed, I strongly recommended her to file TPO, temporary protectional order, against him because he is a very bad aggressor. My client is a victim here.
Was there a dual arrest or what?
No, Your Honor. The victim and the police officer, based on the evidence that they saw, she charged at him because he was telling her to get out of his yard, as he had previously told her to leave the property not to be on the property because she urinates and defecates in the property. And, and maybe that's due to her homelessness, but, um, they were just wanting her off the property. They were not even going to call the police to have her removed. It's just that once she attacked him, which is my victim statement, then that was on. And I know that there was something about her tooth being broken as a result of it or not, but he will still maintain he was defending himself.
It is my client who was a self-defending. It is my client who is a lot bigger at this point.
And it's your client that was on his property. If she had not been there, we wouldn't have this issue.
I think that's the problem. I'm not going to get into the facts and argue that with you at this point. Just looking at the YALA factors, not the specific facts of the case to that extent. I'm going to leave it at the 2,000 surety bond that she already has. She's got the open case for criminal trespass from last year, 2025.
Your Honor, this is her first violence offense, Your Honor, and she only has 3 cycles, and she has no funds to pay for any kind of bond. We asked for signature on bond. There was no other violence.
She has 2 counts of willful obstruction of law enforcement officer, but that was from 2022, and I know that one of them was a DUI that was amended, and the other one, and she also had a DUI that was amended during that time period.
Nothing violent, Your Honor. No violence was committed.
I understand there's no violence before, but there's violence here in this case, and I'll just leave it at the 2,000 surety. Maybe she can do 10% through the jail. And no drugs, alcohol, weapons, or guns while on bond. Stay away from the incident location, and there's no further contact with the victim, correct?
Your Honor, she does not know the victim at all. She was walking by, passing by, and Your Honor, she has no funds to pay for bond. We asked for signature on bond, considering the fact that this is her first violence case.
It's not her first arrest, not her first encounter. So I look at those obviously on a case-by-case basis, and due to the circumstances here, I'm going to leave it at the 2,000 surety bond. She can do the 10% to the jail, or the sheriff rather. Thank you.
This is number 4, Mr. DeWassell.
Okay. This is 26 CR 004975G, Javon Duracell. Pretrial.
Appears to be his first arrest. Usually our jail is pretrial's recommendation.
All right. State.
Yes, ma'am. On March 6th of this year at 710 Peachtree Street Northeast, Atlanta in Fulton County, the defendant was texting another man and the victim confronted him and asked him to leave. While collecting his things, he grabbed the victim's game system, attempted to take it with him. During the scuffle to retrieve the system, the defendant pushed the victim away from him and began punching him with a closed fist, and he dragged him into the hallway by his feet. The parties do live together, and so we are asking for a $3,500 surety bond, stay away from 710 Peachtree Street Northeast, and no further contact with the victim, Quincy Morris. We have not been able to get in contact with him yet, but if we want to sound for him, that would be great, and see if he is on the call.
All right, Quincy Morris. Quincy Morris. All right. Go ahead, PD Bartels.
Yes, thank you, Your Honor. I talked with Mr. Daracell about this situation. As has been noted, he has no criminal history, Judge. It is his first arrest. He is 27 years old. I'm told that he's lived in Atlanta for about 6 years now. I'm told that he is employed at the Hard Rock Cafe on Peachtree. Um, so we would ask for the UJR in this case. Regarding the contact, it's a little bit complicated, Judge. This did happen. Well, it's almost 5 months ago. The date of the alleged incident was March 6th of this year. I'm advised that they haven't had any other difficulties since then. I'm also told by my client that he hasn't seen Mr. Morris, the alleged victim, in a while. He doesn't know whether or not he's still living in this building, 710 Peachtree. Mr. Daracell also told me that he has his own place to stay. It's another apartment in the same building. And it's a very large building, Judge. It's that apartment building at 3rd and Peachtree, right by the Fox. So it's big enough to where, they wouldn't necessarily um, interact with each other, even if they lived at two different units in the same building. So, based on all that, we would ask for a UJR or a signature bond. We would not have an issue with a stay away from Mr. Morris's apartment, but we would ask that Mr. Daracell be able to go to his own apartment in this building because that's his home. And nothing further, Your Honor. The other thing I would add is Mr. Daracell said he hasn't seen Mr. Morris in a while. He actually was wanting to file a missing persons report. So we don't know if Mr. Morris still lives at that building, but I'm just letting the court know all of that out of an abundance of caution.
So same building, different floors?
Yes, ma'am. Different units. Mr. Daracell, y'all are on different floors, correct?
Yes, sir. I'm on 7 and he's on 3.
3. Okay.
Okay, so he wouldn't have a reason to stop at 3.
Right.
All right, $3,500 signature bond through pretrial. I'm gonna ask him to take 4 anger awareness courses through pretrial. That'll be a level 1. Stay away from the incident location or the 3rd floor, it sounds like. Don't go to that floor. No further contact with the victim. He sees him coming, you better go the other way. It's to be 200 yards away from him or 2 football fields away. So hopefully he can do that. No drugs, alcohol, weapons, or guns while on bond.
All right. Thank you, Judge.
Thank you.
All right. Number 7, Mr. James.
Hold on 1 second.
Are we having some weird camera or feedback
I hear it too. Yeah, there's something.
Okay. Making sure it's
Yeah.
not just me.
Hold on 1 second.
Yes, Your Honor.
All right, this is position 7, 26 CR 004978L Raheem Gaines. Pretrial.
Did you say gains?
Yes.
Okay. I show a total of 19 cycles. 12 out of North Carolina and 7 out of Georgia. Last arrest was March of this year out of Fulton County for 2 counts of battery, family violence, and simple battery. 26 CR 001-560L is the case number. Appears to have an open case out of Clayton County for battery. And then had 2 other arrests from Georgia Tech for theft by taking and criminal trespass and willful obstruction. Those 2 cases also appear to be open. A 2017 conviction out of North Carolina for resisting officer. A 2014 conviction out of North Carolina for possession of drug paraphernalia. 2012 conviction out of North Carolina for aiding and abetting larceny. 2025 conviction for driving while license suspended or revoked. And a 2022 conviction for DUI, theft by taking, and driving without a valid license. Level 4 is pretrial's recommendation.
Okay. Dave?
Yes, ma'am. And I'm not sure I heard the 2024 failure to appear and the pending 2020, I think it's a 2025 failure to appear. But on July 25th of this year at 848 Spring Street Northwest, Atlanta in Fulton County, the victim stated that they went out, he and the defendant went out the night before, and the defendant was drinking heavily and was highly intoxicated. He kept trying to start a fight all night because he felt disrespected. Officers observed several injuries on the victim, and the victim stated that these came from the altercation. The victim stated they weren't in a relationship, but the defendant said they are, and they have been for 8 years, and they do live together. So I think there's some misunderstanding between the relationship status. Both parties stated that they had been in previous altercations resulting in arrest. The victim stated that he acted in self-defense because the defendant continued drinking and using drugs after arriving home. So due to his pending failure to appear, his 2024 failure to appear, his other pending charges, we're asking for a $3,500 surety bond, a stay away from 848 Spring Street Northwest, Atlanta in Fulton County, and no further contact with the victim, Stephen Bellamy. And I don't believe we've been able to make contact with him. I don't have anything on my sheet about him. So if we can sound for him, that would be great.
All right. Is it Stephen? Is it Bellamy?
Bellamy, yes, ma'am.
I'm here.
Okay. Do you wish
I'm
to
here.
speak? If you do, if you wish to speak, you need to turn on your camera. All right. Well, do you wish to answer a few questions for the court? Yes or no?
I do. Yeah, I can answer some questions. Yes.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of Mr. Is it Raheem Gaines?
No, ma'am.
Do you want to have any further contact with him?
You asked me, did I want to? Yes, I wouldn't mind it. Yes, I do.
You all are roommates
Relationship.
in a relationship? All right, this just happened a few days ago, so I always need to make sure there's been the ample cooling down period since you've had prior and previous cases. Is that correct?
Yes, yes.
Okay. All right. Anything else from the state or the
Nothing from the state,
defense?
Your Honor.
All right. And you can mute yourself, Mr. Bellamy. Thank you. And you
Okay.
can continue listening in.
All right. Thank you.
Uh-huh. Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Gaines. He tells me that he's lived in Atlanta for about 8 years. He is self-employed. I'm advised he does cooking and food-related social media promotions. I'm also advised that he and Mr. Bellamy work together in that endeavor. So he's concerned that a no further contact order would possibly affect both of their livelihoods for that reason. He does have he's got the one battery. He's already got a bond on another state court charge. But regarding this case, we would ask for a $1,000 bond, Judge. We think that would be sufficient to assure his appearance in court. And for the reasons that we mentioned and that Mr. Bellamy indicated he wasn't in fear of his well-being, we would ask the court to consider a no further violent contact order and nothing further at this time.
No, they have too much history with violence, and I'm wanting to make sure it's finally going to stop. And this one, it's just a day or so ago. So I'm going to go with the $3,500 surety bond. Stay away from the incident location. No further contact with the victim, to make sure there has been the cooling down and that they're not going to have any more cases. So the defendant will need to go find somewhere else to live. In the meantime, if he gets out on bond, stay 200 yards or 2 football fields away from the victim until there can be some cooling down. No drugs, alcohol, weapons, or guns while on bond.
And since he's been living there, Judge, could he go back one time with a police escort to get any property that he may have?
One time police escort. Do not go back alone, Mr. Gaines. All right, thank you.
All right, thank you.
Bill? Come on, you go. All right, number 2, Mr. Coles.
26 CR 004985C Corey Coles, pretrial.
I'm only showing one prior arrest from February of 2025 out of Clayton County for simple battery. There's no disposition, so the case appears to be open. UJR through the jail is pretrial's recommendation.
Okay. Okay.
Yes, ma'am. On July 25th of this year at 1690 Westlake Court Northwest, Atlanta in Fulton County, there was a verbal dispute between the victim, Juanita Bryant, and the defendant, and he put his hands on her and shoved her around, as well as smashed her phone and tore her purse. There were no physical marks this time, but there are previous incidents, says the victim. The defendant denied the altercation being physical, and when asked, the 17-year-old son present and witnessed the incident stated that it was his father who initiated the altercation and he saw both parties shoving one another. And since he has a pending simple battery case, we do not yet have the disposition on that. We're asking for a $5,000 surety bond, $3,500 in the simple battery, and $1,500 for the criminal trespass. Stay away from 1690 Westlake Court Northwest, Atlanta in Fulton County, and no further contact with the victim, Juanita Bryant. And nothing further, Your Honor.
All right. So Juanita Bryant on Zoom.
Oh, and I apologize. I forgot to ask.
No, Juanita Bryant. I don't think so. All right, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. Coles. We would ask the court to consider a signature bond or a UJR in light of his very limited history. At his age, he's 51 years old. He does deny that he initiated this encounter. He said that Ms. Bryant had taken his bank card back and he was trying to ask for that back from her, and she was upset about that. My client indicates that he is on disability, Judge. He has diabetes. He has lost several toes from both of his feet. He has lived in Georgia since 2006. He has family, including aunts, cousins, and extended family, all in the metro Atlanta area. So given all that and given his almost non-existent criminal history, we would ask for a signature bond. We would ask for no further violent contact order, Judge. I have not been able to reach Ms. Bryant and talk with her. That's all from defense right now.
We also have not been able to reach out to the victim, Your Honor, or get in contact with the victim, so we would ask for no further contact as of this time. They have not really had a sufficient cooling off period. And again, he has a pending 2025 simple battery, but we don't yet have the disposition for that.
Okay. And we don't know if it's the same victim or not.
No, ma'am.
I believe it's not. For what he does deny the allegation, Judge. I believe it's something that allegedly happened in a convenience store, the other case in Clayton. So I'm told that it's not Ms. Bryant in that case.
Well, it's so close in time, a little over a year, but so he has 2 back-to-back open simple battery cases.
Yes, ma'am.
So I'm going to give him the surety bond, $5,000, $3,500 on the simple battery, family violence, $1,500 on the criminal trespass. Stay away from the incident location. No further contact with the victim, Juanita Bryant, and no drugs, alcohol, weapons, or guns while on bond.
That's
That should be,
5,000 total.
yes,
All right, I've got that.
3,500 and 1,500.
Thank you, Your Honor.
Thank you.
Number 18, Mr. Metz next.
This is 26 CR 004964L. Mr. Metz, pretrial.
Yes. This appears to be his first arrest. UJR through the jail would be pretrial's recommendation.
All right.
Is this Deshaun Tavius Metz?
Yeah.
Okay, I just
Correct.
have him as Deshaun Metz on my sheet. On Saturday, July 25th of this year, officers were dispatched to a domestic disturbance call at 2479 Abner, and that's spelled Abner Terrace. Prior to the arrival, they reviewed a previous call for service at the same location that had occurred approximately 1 hour earlier. A different officer responded to that incident and advised the officers responding to this incident that Deshauntavius Metz was identified as the predominant aggressor during a physical dispute with his mother, Bianca Metz. Officer Thomas advised that Mr. Metz was no longer on the scene during his investigation. He further stated that Grady EMS personnel responded to evaluate Miss Metz for injuries she sustained after Mr. Metz placed her in a headlock. According to Officer Thomas, after receiving an eviction notice, Mr. Metz became extremely angry and aggressive. He forcibly entered the victim's bedroom while yelling, "Why are you doing this to me? I'm going to kill myself." Miss Metz attempted to push him out of the bedroom, at which point Mr. Metz pushed her in the jaw, placed her in a headlock, and struck her multiple times in the head and jaw. The victim stated that both of them fell to the floor during the struggle, and she fought back until she was able to get on her feet and run toward the front door. The defendant then blocked her exit, produced a firearm, and threatened to shoot himself. In an attempt to escape, the victim knocked out a window screen and called the nearby neighbors for help. A neighbor handed her a phone through the window, allowing her to call 911. And so we are asking for $2,500 on the battery, family violence, and $500 on the obstruction, surety for both. No further contact with the victim, Bianca Metz. Stay away from 2479 Abner Terrace, MHAT and FFA. And we would like to ask that he surrenders the firearm that he threatened her with. I know that you're going to ask for that, but if we could have him surrender that within 48 hours of release, that would be great, since he did use it during the assault. And nothing further, Your Honor. We have not been able to contact the victim, but if we can sound for her, that would be great. Her name is Bianca Metz again. Now, nothing further, Your Honor.
Bianca
Sorry.
Metz. Bianca Metz. And you said you were asking for a surety bond, and you said BHET, and what was the other? FAAA.
I have FFA. I'm not sure what that is. I'm sorry, I did not prepare this case, but I have FFA. Oh, maybe forfeiture of the firearm. I bet you that's what it is. Forfeiture of the firearm within 48 hours of release.
Gotcha.
Apologies, Your Honor.
That's okay. All right, go ahead, PD Bartels.
Yes, thank you, Your Honor. I did speak with Mr. Metz. He does deny the allegations in the warrant. I would note that there's not any third-party witness that's mentioned. I just wanted to clarify a couple of things. In the warrant, the allegation in the warrant is that he produced a firearm and threatened to shoot himself. Judge, there's nothing in the warrant about him threatening to shoot his mother. The warrant also states that Grady responded to the scene to evaluate Mrs. Metz, but it also states later on that Mrs. Metz did not appear to have any injuries. So I would submit that this is, the allegations would support simple battery as opposed to battery. He does not have any criminal history. He is 28 years old. He does work full-time, I'm told, at Plastic Pack. That's a water bottle manufacturing facility. He was born in Atlanta, I'm told, Judge, and his entire family is here. So he's gainfully employed, has no criminal history, and has ties to the community. No further contact order would not be an issue. He has been staying at his grandmother's place for some time. So we would just ask for a UJR or a signature bond through pretrial, and would not oppose a no further contact order while the case is pending. And nothing further.
Mhm. Um, I think I'm going to order the surety bond. Even though I know it's his first, it does bother me a little bit. And, you know, even if you say you're not going to shoot the other person, shoot yourself, where's the bullet going to go? It's a dangerous thing. I'm sure the mother is wanting some help for him.
Well, in that case, then if the court's not inclined for a signature bond, we would ask for a low bond on these charges, given his lack of history.
Yeah, I know, but it's serious. I hope he has the firearm. I guess he does. He can turn it over unless it was turned over on that day. Looks like
I
he
don't have
don't
anything.
have that.
I don't have
Well,
anything in the report stating that, Your Honor.
and
So if we
it's
could
not,
require that, that would
he's
be great.
not, well, he's not charged with anything involving a firearm.
Well, but they have it in the report and in the warrant, right?
Yes, Your Honor.
But he had one. Maybe he got rid of it or they weren't able to find it. I don't know. And I know it's his first arrest, but it's pretty serious. I would obviously want him to be evaluated by a social worker to see if there's some services that he may need, or if there's something going on that he needs help with, they can provide some wraparound services for him. How old is he again?
He's 28, Judge.
And we haven't been able to speak to the mother. I don't know if she's terrified, if she's hiding, if she's scared. I would love to know that, to understand what could have possibly been going on that day, or if he was just having some type of meltdown. Your client wants to talk. I'm not sure if your attorney wants you to speak, Mr. Metz.
Sir, what kind of question do you have?
I was trying to make a statement that I remember putting my hands on it. We was arguing, but it never turned physical. I never put my hands on my mom.
Okay. All right. Well, the judge is clear that you are denying the allegations, Mr. Metz.
But it was a threatening situation that was created, and we want to make sure that doesn't happen. I assume he's going to have somewhere else to go live.
Well, there is an eviction going on, Judge. So, you know, he will need to find someplace else to stay.
Oh, mom has already filed an eviction.
That's what it appears from the warrant. So again, no further contact would not be an issue.
All right. Technically, I guess, you know, he gets I will do the $3,000 signature bond through pretrial. I'm going to put him at a level 2. And that will be 2,500 on the simple battery, family violence, and 500 on the willful obstruction, for a total of 3,000 signature bond. I'm going to ask that he take 6 anger awareness courses through pretrial, social worker visit to assess if he needs some services. I'm wondering about the BHET, if he, you know, was having an issue with wanting to harm himself that day. So maybe the social worker will be able to speak to him about that.
I think they'll be able to assess that, Judge.
All right. And I want him to stay away from Abner Terrace, stay and have no further contact with his mother for right now until we can cool this down. This just happened. So no further contact and to stay away.
The firearm, Your Honor.
Oh, and surrender the firearm within 48 hours of his release to the sheriff's department, I guess.
Very well. Thank you, Judge.
All right, thank you.
This is a level 2?
Yes, level 2. Say that again. We didn't hear you.
5.
Was that 5?
5.
5?
25. 25.
25. Okay.
There's
Sorry, I couldn't
something going
understand
in and
that.
out. Right. I think it's going in and out.
The
so
sound
I'm
is
able to hear.
fading in and out.
It's the audio at the jail.
Oh, yeah. 26
you.
0049 Eric Chappelle, pretrial.
First arrest, UJR jail is pretrial's recommendation.
All right. State.
Excuse me, Jan, I show that there's a consent filed in this.
Oh, this is a consent bond?
Yes, Your Honor, you've already signed it, so I thought he was out already on his
Oh,
way.
okay.
He had a private attorney.
Mm-hmm.
What do you think with that?
Did you want?
But yeah, go ahead and just say what it is so the jail will know.
Okay.
Oh, you can read it, Miss Lewis.
No,
She
that's
has it.
that's the state. They
Huh?
Okay, hold on a minute. I have to find it. Right. Yes, it is for a $5,000 surety bond. There is 4 anger management classes through a certified provider, no contact with the victim, Timothy Porsche. Stay away from the 12595 Crab Apple Road in Milton, Georgia. No alcohol, drugs, weapons while out on bond, no further violations of the law. I believe this was his first offense. I saw Mr. Porsche on earlier. If the court would allow him opportunity if he would wanted to say something since he is on the call.
Mr. Porsche? Mr. Porsche. All right, if he doesn't want to say anything, there's a consent bond.
They're coming on, Jones.
Oh.
I guess they don't know how to work the camera.
All right, I would like to move along. We have a consent bond. All right, go ahead. Next.
No, 5,000. 5,000 good bond or 500 good bond?
It's a $5,000.
It's a 5,000 surety.
Right.
Sure. 31, Mr. Williams.
20.
31.
We cannot hear. 20, I don't know, 5 maybe?
Was that 31
No,
or
it did
21?
25.
Was that 31 or 21?
31.
31. Okay. This is 26 CR 004991D, Julian Williams, pretrial.
He has 4 cycles. Last arrest was August of 24 out of Johns Creek for a DUI. 26 CR 003081D. And he had 1 prior DUI arrest from 2013. That case was no prize. Level 3 would be pretrial's recommendation.
You said level 3?
Yes.
Okay. Thank you.
Apologies. What case is this?
31, Julian Williams, DUI.
Oh, yes. Judge, this was a interesting. He was at 708 Cypress Point Street in Johns Creek on July the 25th, driving on the roadway of the complex. It appeared that from the pool area, the officer observed slurred speech and smelled alcohol, watery eyes swaying. Our bond recommendation is for a $5,000 surety. We would ask for no driving at this time. This is the 2nd and 5 is what I have. So that's our no alcohol, drugs, or weapons while out on bond. That's our recommendation.
All right. PD Kim?
Yes, Your Honor. Mr. Williams, at 41 years old, he has been here in Georgia for
It's terrible. The sound is terrible. We're getting like every other syllable.
yeah,
Jill, anything to do to sign off, come back, or
no, it's a construction that is going on right next to us, so we cannot erase it. Construction is going on.
I don't even know what you just said.
We have a construction going on right next to us.
Oh, do you have construction going on? We heard that. Okay, why did it get better for a moment? Did they stop? I don't know. Okay, let's try it again, PD Kim. Let's see if we can hear you.
41 years old. He has been here in 32 years. Georgia State University.
I heard 41 and Georgia State, nothing in between. Is he 41?
Yes.
And
Yes.
then I heard something about Georgia State, but I didn't hear other stuff in between.
He's studying journalism.
He what?
He studied journalism at Georgia State University, Your Honor. And he also is gainfully employed at Steakhouse, Stony River.
Can you hear Ms. Evans Battle?
She's breaking up, but I could hear she said something about Georgia State.
Well, she said some other stuff after that, but we don't know what that was. Let's try again. When it gets good, then it gets bad.
My client claims that he was not driving, was not even inside of the car, but he was arrested.
This another one claims it wasn't them. They weren't even there. He wasn't driving the car and he wasn't inside. How did he get arrested?
Was arrested outside of the car when he was not driving his car.
There's a different charge for that too. How'd the car get there by itself? I know you don't want to answer that, but there's
Your Honor, that incident place is literally 300 feet away from my client's place. So he's willing to stay away from that location as long as he can go back to his place. And
I don't know what you said. I saw you smile on your face, but I could not tell what you said.
She said that it's 300 feet away from her client's place and that he would agree to stay away from that location.
That's that. Now my problem is driving while drinking. Maybe he won't walk over there, but the problem is driving.
he was not driving, he's saying, Your Honor, he would like to ask for most possible bond, signature on bond preferably.
No, I mean he's got 2 other DUIs and now he's got 2 and 5 or 2 and 10. What was the state's recommendation?
It's for a $5,000 surety, because it is the second and 5.
Mm-hmm.
$2,500, 31, Your Honor.
Where does he work?
Stony Steakhouse at bank, local bank, part-time. He's a caregiver for his mother, who is 5 years old, and he has a child who is under 18 years old. He also is
So he doesn't work. He's a caregiver for his mother and has an 8-year-old child. Did I hear that right?
resides with his child, and Your Honor, he works at Stony River Steakhouse.
Oh, okay. I'm going to give him a surety bond, $5,000 surety bond. He is to not drive. There's no driving. I don't even care if he has the credentials to drive. He needs not drive. He needs to get an Uber until we can sort it out. No drugs, alcohol, weapons, or guns while on bond. And yeah, you can stay away from that intersection if that helps you. But the biggest thing is he need not drive. You
And he
know,
have limited driving permit, Your Honor, for work and medical.
I don't like them, they're out for DUI and then they get a temporary driving permit and then get another one. So I'm not enthused by a temporary driving permit. You can get an Uber to work or a Lyft, or somebody can take them. So I'm going to say no driving right now. No drugs, alcohol, weapons, or guns while on bond. That's it.
All right, number one.
Say that again, or maybe ASG Evans Battle can hear you better than me. Mine is terrible.
I heard one, Jamari Carter. If that's right, do a thumbs up.
Oh, is that correct? Who is it again, Deputy?
One, Mr. Carter.
Okay. 26 CR 004984L, Jamari Carter. Pretrial.
3 cycles. Last arrest January of this year for possession of a firearm by a convicted felon. That's an open case, 26 PI 000749. Appears to be on probation for aggravated assault and robbery, 24 SC 001502. And that disposition was in August of 2024. Level 3 is pretrial's recommendation.
Okay. Hey, state.
I'm so sorry, Your Honor.
Yeah, bless you.
On July 24th of this year at 649 Mayland Ave, Southwest Atlanta in Fulton County, the defendant was sleeping on his mother's porch, and when she told him to leave, he did, but he came back later that day. His girlfriend was charging her phone at his mother's residence, and he entered the home without permission, and the victim again instructed him to leave. As he was I'm so sorry. As he was leaving, he started arguing with the victim over her cats, stating he was going to sell the cats to make money. During the altercation, he shoved her, causing her to lose her balance, and he then elbowed her in the jaw. The defendant returned to the home approximately 4 times, making threats and attempting to gain entry into the house. The victim stated there were several ongoing incidents between her and her son. She stated that she asked him to leave 4 months ago, and he has been staying elsewhere. The victim is named Brittany Carter, and due to his pending probation violation and his also other 2026 charges, we're asking for a $4,500 surety, a stay away from 649 Mayland Avenue, and that's Mayland Avenue, Southwest Atlanta in Fulton County, and no further contact with Brittany Carter. And we have not been able to make contact yet, but if we can sound for her on the line, that would be great.
All right. Is the victim on? Say the name again.
Brittany Carter.
Brittany Carter. Nope. All right, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. Carter. He is 19 years old. He denies the allegations in terms of, well, first of all, there's no allegation of any visible injury. He indicated that his mother started pushing him and putting her hands on him first. I'm advised that he does work. He's been hired at a restaurant and food preparation business called Hungry AF. He indicates that he has been staying with his grandparents. So, and no further contact and a stay away order would not be an issue. If the court goes with that, we would just ask that he be allowed to go back to the property one time with the police to get any property there if he has any. So, given all that, given his limited criminal history, if there are no allegations of any physical injury, we would ask the court to consider a $1,000 good bond. I think that would be sufficient to guarantee his appearance in court, and nothing further at this time.
And Your Honor, as I stated, she asked him to leave 4 months ago, so there's no reason he should have been on the property at all.
Does he still have clothes at the incident location or her place?
Yeah, he's nodding his head, Judge. I believe he does.
All right, $4,500 surety bond. Um, stay away from the incident location, no further contact with the victim. Stay away, no further contact, no drugs, alcohol, weapons, or guns while on bond. And I guess that's it for now.
Can he have a one-time return, Your Honor, with the police?
Yes, one-time
His
escort
property.
back with the police to get your personal belongings.
Okay, thank you, Judge.
All right.
Number 6, Mr. Ford.
26 CR 004986C. Grayshawn Ford. Pretrial.
First arrest, level 1 is pretrial's recommendation.
All right. Pretrial. Oh, you said first arrest, right? For him, for Ford.
Yes.
All right, state.
Yes, ma'am. On February 12th of this year at 51 Ollie Street Northwest, Atlanta in Fulton County, the defendant assaulted the victim because he had previously given her $100 to get her hair and nails done for Valentine's Day. He became upset after she asked him to watch their 2-month-old child while she showered. He went into her purse, attempting to retrieve the money he gave her. A fight happened over the purse, and he dumped the contents out and then punched her in the back of the head twice, slapped her in the face 3 times, and pushed her to the floor while she was holding the child. He also broke her phone. The defendant fled the apartment before the police arrival. There were no visible signs of injury, and the victim got her things at that time and left as well as the child's. And we are asking for the victim is Michaela Chester, and we're asking for a $5,000 surety bond. Stay away from 51 Ollie Street Northwest, Atlanta in Fulton County, and no further contact with Michaela Chester. And the victim says she will not be on Zoom, but if we can still sound for her just in case, that would be great.
All right. What's the victim's name again?
Michaela Chester.
Michaela Chester. Michaela Chester. All right. PD Bartels?
Yes,
Oh,
thank
hold
you, Your
on.
Honor.
Hold on. There's someone there. Are you
No,
Miss
this not
Chester?
no, this not Michaela Chester. This is his mom. His address is 51 Ollie Street. She doesn't live there. That's his address.
Right.
Do we
I'm
have
told.
another address for her?
Yeah, she stays in Union City, but he stays at 51 Ollie. That's my address. He stay there.
Oh, that's your address.
I
That's
got yeah,
mom.
I got the house for him and my oldest son. That's his address. Him and my oldest son.
Did
And
she
ma'am,
ever live there? Did she ever reside there?
She stayed there for like 2 weeks,
Mm-hmm.
yeah,
but
I'm
she no
told that
longer stay there.
she's
Okay.
at her grandmother's. Is that correct? Yeah.
No, I'm his mom.
No.
I'm
The
Grishon's mom.
victim. No, the
Oh,
victim. She may be staying with her grandmother.
yeah, she lived with her grandmother.
Oh, okay. Okay. Thank you for that.
You're welcome.
All right. Go ahead, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. Ford. As indicated, this is his first arrest, so he has no criminal history. And based on that, and as well as his ties to the community, Judge, he was born in Atlanta. He indicates he was raised in Atlanta, lived here all of his life, and his family, of course, including his mother, they all live here in Atlanta. And Mr. Ford also advised me that he and Ms. Chester do not live together. He advised me that he is staying, or that she is staying with her grandmother, and he lives at the Ollie Street address. So, based on that, we would ask that he be allowed to go back to his residence, but a no further contact order would not be a problem. And again, based on that, we would ask for a signature bond. The alleged date of the incident is February 12th, so it's been over 5 months. and nothing further at this time. Oh, Judge, he also advised me that he works full-time in security at the Stacks condos. That's there in Cabbagetown on Boulevard.
In light of the information about the Ollie Street address, we would amend to just any addresses where she lives and works.
Okay, thank you.
Thank you.
All right. I will order the $5,000 signature bond through pretrial. And that will be a level 1. No further contact with the victim. Stay away from her and where she lives and works, 200 yards away or 2 football fields. No drugs, alcohol, weapons, or guns while on bond. That'll be $3,500 on the simple battery, $1,500 on the criminal trespass.
Yes, Your Honor. And I'm sorry, I failed to delineate that.
Break it down. That's fine. And I guess that's it. No drugs, alcohol, weapons, or guns while on bond.
Yes. All right. Thank you, Judge.
All right.
Thank you, Judge.
And let's go number 11, Mr. Ivy.
This is 26 CR 004957G Zion Ivy. Pretrial.
8 cycles. Last arrest was May of this year for willful obstruction and possession of marijuana. That is an open case 26 CR 003442G. Appears to be on probation for theft by shoplifting 25 CR 004625G. Disposition was August 28th, 2025, 12 months probation. Level 3 is pretrial's recommendation.
All right. State.
Yes, Your Honor. On July 24th of this year, the defendant returned to the business of McDonald's located at 3201 Camp Creek Parkway, East Point, after being criminally trespassed on July 16th of this year. And the case number for that criminal trespass is 26007758. He already has a $600 surety bond set, so we would ask that it remain the same and nothing further. And he stay away from the McDonald's located at 3201 Camp Creek Parkway in light of the criminal trespass.
PD Bartels.
Yes, thank you, Judge. I did speak with Mr. Ivy about this case. He indicates that he's been in Georgia approximately 10 years, and he does have family, including his cousins and aunt that live in the metro area. So he does have ties to the community. Based on the recommendation from pretrial, we would ask if the court would consider a signature bond, partly just because of the nature of the charges. I'm not clear if this is a Riverside case, Your Honor. It looks like he was taken into custody early in the morning on the 24th, which was more than 72 hours ago. I do see that a bond has been set. I don't know if that was part of the warrant or if he went before a judge in East Point Municipal. I don't see any indication one way or the other. If he didn't go before a judge, then it would be a Riverside case. But we would ask the court to consider a signature bond on those bases. If the court's not inclined to do that, we would just ask that the $600 bond remain the same.
I show him booked in on this on July 25th of this year.
Yeah, again, the arrest date, the booking in the Fulton County Jail was July 25th, but it looks like he was taken into custody in the morning of the 24th. So, and again, I don't know if he was taken to East Point Court or not. I don't see anything.
Okay. I will keep it at the $600 surety. Stay away. Stay away from the McDonald's. No drugs, alcohol, weapons, and guns while on bond.
Thank you, Judge.
All right.
I didn't hear the bottom out.
600 surety preset.
Mr. Bartel, he was right. He was directly transferred to, he was at the East Point jail, and it happened on the 24th. They took him to East Point before they took him to Fulton County.
Mm-hmm.
Well, based on that, Judge, it appears that he wasn't brought before a judge within 72 hours of arrest.
But doesn't he have to be in the Fulton County jail? Do they count where he is somewhere else? Because we wouldn't have been able to address him if he spent the first 2 days at East Point. Is that what you have, Ms. Lewis? He didn't get to the Fulton County jail.
He was directly, according to the citation, he was directly booked in to East Point jail on the 24th. And then he was transferred to Fulton County. It says right here, he was turned over and booked over to the staff for booking process at East Point.
That's what I've got in the warrant.
And it has it on a citation too, that he was taken to the East Point jail.
But I thought for Riverside, we still have to have him in the Fulton County jail, no? Am I wrong about that?
My understanding, Judge, is that it's from the time of arrest, but
because I would have no control over him getting a bond if the first 2 days if he was at East Point.
Right. Let me look into that, Judge. If we could revisit this case while we're doing one of Ms. Kim's cases, I can look into that one way or the other.
Okay.
There is a statute that addresses it.
Yeah.
Thank
If
you.
I had time to look and listen, I'm not that good at doing double duty, but if you can.
I'm not good at multitasking, but I'll do my best.
Okay,
Yeah.
thank you.
Thank you.
Yeah, 13, Jeff.
13. All right. This is 26 CR 004959H. Romas Johnson. Pretrial.
First arrest, UJR jail is pretrial's recommendation.
All right. State.
Yes, ma'am. I'm working on getting this warrant pulled up. I don't have a completed, I didn't prepare this case, so give me just a second to get that to come up.
I have it. I have notes. This is a criminal trespass that happened. In this particular case, it appears when speaking with the victim, confirming the information in the warrant that she and the defendant were on and off in a relationship. They weren't currently living together. They don't co-parent. They do co-parent, but they were not living together. He took her phone, and she's also indicated the victim didn't have any injury or anything like that. He has limited prior criminal history. So there would be a bond recommendation would be for the bond recommendation is going to be for a $2,500 surety bond in this particular case. There was some concern about a strangulation issue, but the victim and the cases denied it. We would just ask that that be the recommendation on that criminal trespass. I don't know if she is on the call. Her name is Jordan Ezel. I think I saw her earlier, so she's there.
All right, there she is. Mrs. Zell, do you want to answer a few questions?
Yes.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, thank you. Put your hand down for me. Are you in fear of Mr. Romas Johnson?
Not at all.
Do you want to have any further contact with him?
Please.
All right, and you all have a child together?
Yes, that's why it's very important we have contact. I'm in school and I work, and he's a phenomenal with her.
He may be phenomenal with your daughter, but what about with you?
I'm fine. We may have our disagreements, but I have been in counseling, and so has he, to work on our anger management. And it is definitely a work in progress, but it is coming along. And I definitely believe in him being great for the both of us.
All right, I don't know that there's been the ample cooling down period here to make sure that you are behind it. I know it's his first arrest, but I guess we want to make sure it's the last.
And just so that we're clear, Judge, it's my understanding there's a DA case open in which this victim is a part of it. So I don't know that it's and I just know that from the information contained from the victim advocate. I know the criminal history that I had only showed the driving while license suspended, but there's supposed to be, I have a DA number, in fact. Now that I'm looking at these notes, it's 26 DA 08145.
I'm sorry, are you talking about me or him? I'm sorry.
Him.
For him.
Don't
Oh.
pull your criminal
Yes.
history. No,
Sorry.
you're not being charged. Him. So there is an open DA case.
I have a case with the DA number. It's not the 26 DA 08145. I don't know if pretrial has that. Is that it may be another county why it's listed like that.
Mm-hmm. Well, let's see what who's representing him. PD Bartels or PD Kim?
Yes, Your Honor. That is my case. What was the
Okay.
question regarding Mr. Johnson?
I don't know if you had his arrest record, but we have different information on his history.
Well, the information I have from pretrial is that he has no previous arrests. Now, I do see that there's another case, but it sounds like the allegations arose at the same time. So my position is that he has no previous history. I think this is also a Riverside case, Your Honor. The date of the alleged incident is the evening of the 23rd. And the warrant that I have says that he was taken into custody, and that would be on the 23rd, the date of the incident. And I did find, Your Honor, OCGA, let me pull up the statute. Regarding this, it's 17-4-26. And that says that apparently it goes from the wording of the statute, it does go by the date of arrest. It says, I'm trying to get this to pull up here. Every law enforcement officer arresting under a warrant shall exercise reasonable diligence in bringing the person arrested before the judicial officer authorized to examine, commit, or receive bail, and in any event to present the person arrested before a committing judicial officer within 72 hours after the arrest. So that goes by the date of arrest. So our position would be that based on that, at least on the misdemeanor charge, the felony charge, that's going to be a separate court and a separate issue. But since he wasn't brought before a judicial officer within 72 hours of arrest, we would argue that he is entitled to a signature bond, at least on the trespass charge. And also that Mr. Ivy, in the previous case, would also be entitled to a signature bond under that statute.
All right, hold on one.
Just my information is that the warrant for this particular case was not even issued until the 24th. So the arrest that may have taken place may have been for the felony offense that you're speaking of. So my information is that the magistrate issued a warrant on the 24th and he was arrested on the 25th.
Just on a felony, not.
No, on the misdemeanor case is what I'm looking at, the warrant for the misdemeanor case. That it was issued on July the 24th.
It's not clear exactly. It said he arrived later back at the incident location and he was taken into custody. So it doesn't say exactly when he arrived back.
Hold on 1 second. Let me check something. Hold on. All right, Mr. Bartels, on
Yes, Your Honor.
13 on Johnson, we have the arrest date of the 23rd in East Point or the 24th.
Well, to be candid, Your Honor, it's not clear. The incident allegedly happened on the 23rd, and then it said he came back, but it doesn't say exactly when he came back and was taken into custody. Because it said Johnson later arrived back at the incident location and called 911, and he was taken into custody at that point and transported to East Point City Jail.
All right. And if we're saying that's the 24th out of the 25th,
Yeah,
then
well,
it still would be 72 hours, I guess.
yeah, it would have to be by this time on the 24th. And I'm not seeing any indication as far as how much time passed. Now, Mr. Ivy, I think it's more clear because
Right.
this was in the morning of the 24th, and he was taken into custody right then.
Right.
And Mr. Johnson was not taken into custody immediately.
All right. State, I guess you're gonna argue no or yes.
Which case is this? Are we talking about the Ivy
Johnson,
case?
Johnson.
I got it. Judge, I'm, if the court, finds that it's a Riverside issue, then it is. It's a criminal trespass, and in consideration, he's got no bond set for his PI cases. I'm
That's true.
not doing too much arguing about it.
Gotcha. All right. I will do the 2,500 signature bond through the jail on the criminal trespass.
Okay, thank you, Judge.
All right, thank you. And let's go back to Ivy.
Right.
Johnson, what was the amount on Johnson?
$2,500 signature bond through the jail.
Even though he got jail in his felony case, he has no further contact with the victim.
Who's speaking?
Denise from the solicitor's office.
Who?
Miss Glover from the solicitor's office.
I have it.
Yeah, he went to felony court and got a $23,000 bond. He can have no further contact. He has an ankle monitor paid for by the county. He has to stay away from her.
But was that on the criminal trespass or on the felony case? That's what I keep asking.
That's his.
Judge, Denise, it's okay. It's okay. We're good, Judge. Signature bond through the jail for his criminal trespass. And she was just bringing it to the court's attention that he does have a bond on the felony cases because I said it was in a no bond status. He
Right.
does have a bond with conditions on that case. So
Correct.
that's what she was,
Correct. But
she was
my
just
key was,
explaining.
does he have a bond on the criminal trespass on the misdemeanor
And
case?
he does not, and
Does
the
not.
court is
Right.
going to give him a bond.
Right. And I have to give him a bond on that. Right. All right.
Well, will there be any special conditions with this bond
This-
on criminal
I
trespass?
can't do it with Riverside.
Oh, okay, this
So-
is the Riverside. Okay, you all established that. No problem.
Right.
I
So
hear it.
I don't even, can I do the no drugs, alcohol, weapons, or guns? I don't even know if I
No
can do that.
conditions is my
No
understanding.
conditions. Yeah.
Okay,
That's mine
got it.
as well.
Yeah.
Okay,
No conditions. All
gotcha.
right. Now let's go back to
Mr. Ivy.
yes.
Yeah, he's number 11, Judge.
Thank you. All right. And I had a $600 surety bond. So we're going to change that one, Miss Bridgewater, to $600 signature bond through the jail.
Again, with no conditions.
Right.
Gotcha.
Thank you, Your Honor.
All right. Thank you. All right. Who do we have next, Debbie?
Number 17, Mr. McCoy.
All right. 17, McCoy, 26 CR 004963C. Mr. McCoy, pretrial.
14 cycles. Last arrest was December of 2025 for FTA. Appears to have an open case for aggravated stalking and willful obstruction. That's in Superior Court. And a conviction for battery in 2018. Level 3 will be pretrial's recommendation.
Date?
Yes, ma'am. On July 24th of this year, officers were dispatched to 1899 Metropolitan Parkway Southwest, Atlanta in Georgia, in regards to a criminal trespass complaint. Upon arrival, they met with the caller, Miss Andrea Bailey, the emergency coordinator for the property. Miss Bailey stated that the individual, later identified as Miss Alavius McCoy, had been previously observed doing an act on the property and as a result have been permanently banned from returning. At the time of initial contact, Ms. Bailey was unable to provide documentation of the prior incident or the criminal trespass warning. The defendant was detained while they conducted a thorough investigation. During the investigation, they learned that after the defendant returned to the property, staff allowed him in and provided him with clothing and food. Later on, the staff then instructed him to sit in a chair with them and never told him to leave, but called Atlanta police there to arrest him due to him telling him that in the past he was banned and him leaving before they arrived. Due to an apparent mental health condition, Mr. McCoy was unable to provide his name or information. Another employee at the location was able to provide Miss Bailey with Mr. McCoy's information as well as documentation confirming that he had previously been issued a permanent criminal trespass warning from the property. Based on the investigation, the confirmation that Mr. McCoy knowingly returned to the property after having been permanently banned, they arrested him for criminal trespass. He has a $1,000 surety bond already set, so we're asking for no further contact with Andrea Bailey, who is the emergency coordinator for the property, and stay away from 1899 Metro Parkway Southwest due to the permanent criminal trespass ban, and a social worker for MHET, and nothing further.
All right.
Yes, Your Honor, that is my case. I have spoken with Mr. McCoy. It looks like, interestingly enough, there was another case on the calendar from this cooling center. I am advised, well, Mr. McCoy is 40 years old. I'm advised that he was born in Atlanta and has lived here all of his life. He has extended family in the metro Atlanta area, so he does have ties in the community. He does do work. He works for Tom Howard Home Improvement. That's a remodeling contractor, so he is employed. I do think a social worker visit might be helpful if the court wants to provide for that. And given the nature of the charges, we would ask the court to consider a signature bond, or if not, we would just ask that the $1,000 bond remain the same if the court's not inclined to do a signature bond.
Okay, the $1,000 surety bond remain the same. That's the existing surety bond now. He is to stay away from that location and no further contact with the victim. Is it Angela Bailey?
I believe it's Andrea Bailey. I'm sorry, I switched
Andrea.
off that screen. Just one
Okay.
second, Your Honor. Andrea Bailey, yes, ma'am.
Okay. And no drugs, alcohol, weapons, or guns while on bond. That should be it.
All right. Thank you, Judge. That's it.
Mm-hmm.
And number 21, Mr. Boyer.
26 CR 004967B, Kelvin Moyer. Retrial.
He has a total of 19 cycles, 9 out of Georgia, 10 out of North Carolina. Last arrest February of this year out of Clayton County for theft by shoplifting and willful obstruction. That case appears to be open. Appears to be on probation for, looks like 3 separate cases that was all sentenced on the same date. 2 is for theft by shoplifting. The 3rd case is for theft of lost or mislaid property. The disposition date was January of this year, 12 months probation for each. A theft by shoplifting conviction 2025, FTA from 2025, and then a possession of marijuana conviction 2006 out of North Carolina, and an assault conviction 2010 out of North Carolina. Level 3 is pretrial's recommendation.
Okay.
I'm sorry, what position is this?
21.
Thank-
Moyer. Kelvin Moyer. State.
Yes, ma'am. On July 24th of this year, officers were flagged down by a store clerk at the Chevron gas station located at 1337 Virginia Avenue, East Point. I'm so sorry if I butcher this, Mr. Sefu advised that he needed assistance because 3 individuals had shoplifted merchandise and were attempting to leave the store. The officers accompanied Mr. Sefu to the Chevron, where he identified the accused as one of the individuals who had shoplifted merchandise, along with 2 other males who had entered the store with him. They made contact with the accused and the 2 males, later identified as David Allen Stevenson and Benjamin Cavoine Moyer, in the parking lot. Sefu pointed to the merchandise in the accused's hands, consisting of one 32-ounce fountain drink and one 16-ounce purple Powerade, and stated in the presence of both the accused and the officer that the accused had not paid for either item. The accused admitted that he had carried the merchandise past all points of sale and exited the front door without paying for it. When asked whether he had purchased the items, the accused stated he had not. The officers advised the accused that if the merchandise was not paid for, he would be placed under arrest. One of the defendants agreed to pay for the merchandise. While walking back inside the Chevron, the defendant asked the accused how much money he had, and the accused replied, "I don't have any money." Once inside the store, Mr. Sefu scanned all of the merchandise that had previously been shoplifting, and then Mr. Stevenson, one of the other defendants, refused to pay for the merchandise. An uninvolved customer volunteered to pay for all the merchandise, and the payment was accepted by Mr. Sefu. After the merchandise had been paid for, Mr. Sefu requested that the criminal warnings be issued to the accused and Mr. Stevenson and Mr. Moyer. The officer requested the accused, Mr. Stevenson's and Mr. Moyer's full names and date of birth so that they could complete the criminal trespass warnings, and the accused refused to provide his identifying information. The officer advised the accused he was not free to leave. However, while the officer was engaged with the other defendant, Mr. Stevenson, the accused walked out the front door of the Chevron. After exiting the Chevron, the accused fled on foot, and the East Point officers later located the accused on the 4th floor of the O'Connell Lodge, located at 1360 Virginia Ave in East Point. After being detained, the accused denied ever being at the Chevron gas station. So he has a $1,500 surety already set. No further contact with Mr. Sifu, and stay away from both the Chevron, the Arby's, which shares the Chevron's parking lot, and the O'Connor Lodge. And I have that as 1337, 1359, and 1360 Virginia Avenue in East Point.
All right.
And Your Honor, I was just told that this is a co-defendant in the Stevenson case, and the defendant in that case got a $2,000 signature on bond through pretrial services level 1.
Okay.
Yes, Your Honor, I have spoken with Mr. Moyer. He did indicate that he thought that he was supposed to leave. He did not, he was not aware that the officer had wanted to stay. He said that the cashier, which I guess that's Mr. Sifu, had told him to leave. So that's why he had left. That is what my client tells me. He is 39 years old. I'm advised that he was born in Atlanta, has lived here all of his life, and has family here. I'm also advised that he does construction work for David Stevenson Contracting Company. So he is employed. He does have ties to the community, and he does deny the allegations, indicating that this was a misunderstanding. Based on all of that, we would ask the court to consider a signature bond. If the court is not inclined to do that, we would ask for a $1,000 good bond. No objection to a stay away order from the location. I'm not sure why a stay away from the Econo Lodge would be called for. It looks like that's where he was arrested, but there's no indication that he was doing anything illegal there. So that's what we would ask for, and nothing further at this time from defense.
Let's see. On the surety bond on willful obstruction, I think that's a restricted one. Let me see. All right. So I will give it a, I don't know, what was the state's recommendation again? I'm sorry.
A $1,500 surety has already been set, Your Honor.
Oh,
And we'd ask that it remain the same.
all right, $1,500 surety. Remain the same. No drugs, alcohol, weapons, or guns while on bond. Stay away from all of that property, however it goes. The Chevron versus the.
There's a Chevron, and then it shares a parking lot with an Arby's, and then they arrested him at the O'Connor Lodge.
All of those locations, I guess. All right.
Thank you,
I
Your
guess that's it. All I can do.
Yes.
All right, thank you.
Yeah, roll 23, Mr. Robinson.
Which number is this?
23.
23. Thank you.
You're welcome.
Charles Roberson, 26 CR 004980A. Death by choking. Pre-trial.
Just give me one moment.
Okay.
I know I have 8 cycles, but I don't have his history for some reason.
Okay.
If the state has it, but I'm going to check real quick.
Okay.
If you want, I can give you what I have.
Okay, that's fine.
I have actually, his last conviction was in 2019 for theft by taking. Prior to that, he had a criminal trespass and battery substantial harm. He had a 2010 battery visible harm obstruction. Well, they weren't prosecuted, so I won't even go into it. But because in relationship to this is a theft by taking case. He took a fanny pack that belonged to Sharhonda Proctor. It appeared that he was at a location and was attempting to start a fire. And she told him that he needed to leave and he was pushing a buggy. She didn't realize at the time that he had taken her fanny pack with things, a wallet and other items that were inside of it. There were some other people that were in the area indicating that he was selling the items that were in her fanny pack out of it. She said there was like a charger and a wallet and those types of things. And this happened at the Circle K gas station at 1820 Hollywood Road, Northwest Atlanta. Although it appears to be his last arrest was some distance in time is for the same offense. Our recommendation is for a $2,000 surety that's already been set. We're just asking that it remain the same. No alcohol, drugs, or weapons. Stay away from the Circle K gas station location and no further contact with Sharhonda Proctor. And I don't see that she is on the call.
All right, and it was how much preset?
It was 2,000 surety.
Okay.
Yes, Your Honor. Mr. Robertson is 48 years old, born and raised here in Georgia, Your Honor. He does have 2 children, and one of them is still minor. After graduating from high school, he was working hard. However, ever since his mother passed away, he has been struggling. He's residentially challenged at this point, and also he does need some financial help. He has no financial means to pay for any kind of bond. We asked for signature on bond for theft by taking, and right now he has because of the shot that he got a couple of years ago, he has a metal rod in his leg, so he cannot even walk well. We asked for a signature on bond because considering the fact that last arrest was more than 7 years ago. Thank you.
I'm gonna leave it at the preset surety bond of 2,000. I think that's fair, given the cycles and the circumstances. Stay away from incident location. No drugs, alcohol, weapons, or guns while on bond. $2,000 surety. Anything else that I need to order?
There's 10%.
Oh, a social worker visit?
Yes.
Okay.
Thank you.
Uh-huh.
All right, number 30, Mr. Walker.
This is the one that we have a plea deal.
Okay.
The paperwork was already submitted.
On position 8. Which one?
It's on Walker, Alwyn Walker. They're doing
I was looking at 7 and 8. Is 27 or 28?
Position 30, Your Honor.
27. No?
no. Position
Oh, 30.
30.
Thank you.
It's gonna be a plea.
Plea 26 CR 004990A Aldwin Walker. Charge of 1 count of criminal trespass.
Yes, Your Honor.
Plea.
First, let's get the defendant in the chair.
Huh? Oh, hold on. All right. Go ahead, State.
Yes, Your Honor. In this particular case, the state, as to the sole count would, it would be commute to time served plea. It appears from our record is 3 days. So I guess we would say for the purposes of the order, it would be the state would ask for him to serve 6 days credit for time served, balance suspended. And it's my understanding that he wishes to enter a NOLO plea and the state is not opposed.
All right. So Nolo
Okay,
plea.
she wrote up as just as a time served, but I see
It-
what you're saying.
Okay, there,
I
yeah,
was just
some,
going to, I had it as
okay,
time
there,
served
because
already.
different judges, different,
I know.
different
So you,
judges, different rules. I want to just say time served.
and that would have been fine. That would have been
That would
fine.
have been fine with me.
Okay, time served.
Thank you.
That's what we're gonna do,
3
stipulate the
days, time
identity,
served. Thank you.
identity, venue, and a factual basis for the plea.
All right. P. Kim,
Yes, Your Honor.
that's your understanding?
Yes, Your Honor.
All right. And do you still stipulate?
Yes, Your Honor.
All right. Mr. Walker, understand you wish to plead guilty. Is that correct?
Yes,
No
ma'am.
low content.
Huh?
No content day, Your Honor.
I'm sorry?
No low content day.
No more what?
It's a
No
no-low
low,
plea.
Judge, no
It's a
low.
no-low plea.
Oh, I thought we said, well, time served. So he wants to use his NOLO? Can't use it again for 5 years.
Yep.
All right, that's fine. So I understand that you wish to enter into a NOLO for this criminal trespass charge. Was that correct, Mr. Walker?
Yes, ma'am, that's correct.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am, I do.
All right, I'm going to ask you a series of questions and make sure that your plea is free and voluntary. First one is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No, ma'am, I'm not.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am, I am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am, I do.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am, I am.
Has anyone told you that you will receive a lesser sentence just for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am, they didn't.
And you do understand that if you're on probation, it could be affected by a guilty plea today?
Yes, ma'am, I understand.
All right. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, yes, yes.
All right. So as to the charge of criminal trespass, how do you plead?
I'm guilty.
Oh, no
Not-
low.
No, no, no low. The no low. The no low. That's
NOLO. Okay, gotcha. And we take your NOLO. And I don't think you have any conditions, do you?
no, ma'am.
Okay. All right. That's it. Is your NOLO is accepted.
Thank you.
Thank you, y'all.
All right. Thank you.
Come on, come on, come on, come on, come on. Oh, she got order up. Come on, come on. Come on, right there. All right, what? Big little crap in your ass. Come on. Yeah.
I believe there are 2 waivers.
2 waivers.
At least.
I
Yeah,
know
I have,
there are 2.
I have 3 waivers as well, Your Honor.
All right. Let's start at the top of the calendar and go through them. What you got, Miss Bridgewater, number 8?
Okay, as far as number 8, I guess that would be the next one. Anthony Wayne Garrett.
Right. Is that a waiver?
That is a waiver, Your Honor. I did want to ask about Mr. Barnett, Charles Barnett. He's not on the calendar. Is that correct?
Don't see it.
He is not on the calendar, and I was going to ask Judge Mency if we accuse the case, if she's on the bench tomorrow, we could add it to the SAP calendar. I'm sorry.
Okay.
It's actually a felony case, and so it's against an officer. And then speaking with the officer, he charged it that way because he didn't want to pursue the felony case. So we need to fix the warrant. I guess that is the best way to describe what needs to happen and accuse it as a misdemeanor.
Yeah, Judge
Okay,
Long says tomorrow is Tuesday. I'm sorry, it's Judge Williams. for SAP tomorrow.
Yeah, if it's tomorrow morning, he would still be inside the Riverside
Right.
time period. So,
I'm
okay.
I'm sure we don't.
Right, and so that was what I was
Reset.
thinking, that we would go ahead and do whatever, figure out what we're gonna do with it.
Right, exactly. I'm
So
sure she'll
reset
be
28th.
amenable to listening to that.
All right, so Mr. Garrett.
Okay. So that is 26 CR 004979J, theft by shoplifting, pretrial.
Yes, he has 19 cycles. We're on position 8, right?
Yes,
Ma'am.
Garrett,
Okay.
Anthony Garrett.
19 cycles. Last arrest was from July of 2025 for theft by shoplifting. Appears to be on probation out of COP for aggravated battery. From 2012, it was a 15-year sentence. A 2025 criminal trespass conviction. 2022 disorderly conduct conviction. Give me 1 second. It looks like I have two people criminal histories merged together.
Yes, I have him booked in July 26th for driving, failure to signal lane change, possession of a firearm under commission of a felony, possession of a firearm by convicted felon, 3 charges of possession of controlled substance, and theft by shoplifting. So
There are 2 people in the jail right now named Anthony Garrett. That
Oh,
may
really?
help explain it. Yes.
Both Anthony Wayne, or is Wayne gonna be for
There's
one
an
and not
Anthony Wayne and Anthony Dwight.
Oh, okay. Okay.
Yeah. Now I'm a little confused because Mr. Anthony Dwayne Garrett looks like he already has a UJR on the shoplifting.
Does it?
it makes me wonder if this is because we accused the case this morning, and I also had the same question, Your Honor. I show him as
Mhm.
having an unsecured judicial release, and he was released July 28th, 2025.
Oh, so he's not there.
Well, he is, but he's got a felony charge with
He's
no
there on
bond.
his felony.
Right.
Yes.
Maybe so.
As far as I
Yeah.
can tell, he's got a UJR on this
Right.
charge.
On this charge. Is that deputy? Do you have that? Or does anybody else have it? Look on his booking screen.
Yes, ma'am.
Huh?
Yes.
Oh, you have that too? Okay. Well, we can go on, correct?
Yeah, and he's waived his appearance. So we would just ask that this case be further noticed, I guess, to jail jury
Right, Miss Lewis?
or SAP.
I don't think, well, does he,
It will
well,
go, it will go to SAP unless you waive arraignment.
yeah, is he
That
waiving
child be
arraignment?
interested appearance, but it's gonna go on to SAP.
Yeah, let's put it to SAP then.
Okay.
We've got that felony. Thank you.
Mm-hmm.
And this is a UJR?
Yes, it's a UJR.
Right.
Okay, so he'll be reset to the SAP calendar for August 11th.
Correct.
Thank you.
Okay.
Okay,
And
next
what
wave, I'm
else?
going through the calendar. How about position 19? Daryl Mitchell.
Yeah.
That's also a waiver. I sent all of those earlier.
Okay.
It's a trespass. Well, we'll hear from pretrial in the state.
Okay.
And
Go ahead,
I'll address
pretrial.
that.
Yes, he has 1 second. Okay. Okay, there we go. I show. Give me 1 second.
Mm-hmm.
I don't know why I don't have this history.
I have 17 cycles with a 2025 failure to appear. If you need for me to put more detail in, Your Honor, I can.
Oh, I have it. That's who history I had his mushed up with. Okay. 17 cycles out of Georgia, 1 out of Alabama. Last arrest September of 2025 for criminal trespass out of Union City. FTAs, 2 from 2025, 1 from 2019. Disorderly conduct conviction in 2022, 2 counts, and a criminal trespass conviction in 2025. Level 3 was pretrial's recommendation.
Mm-hmm. Okay. All right, state.
Yes, ma'am. On Saturday, March 7th of this year, Officer Lilly with the Union City Police Department was patrolling within the jurisdiction of Union City when he stopped at the Texaco located at 4430 Flat Shoals Road, Union City. While at the location, he observed a subject on the property who had previously been seen from the location, CT'd from the location. Upon observing the subject, the officer activated the department-issued body-worn camera and then made contact with the subject, who was identified as Daryl Mitchell. Mitchell had been trespassed from the location on April 11th, 2025, and was not able to come on the property until April 8th, 2028. The officer ran Mitchell's name through Fulton County Dispatch, and it returned a warrant out of Union City for failure to appear on a criminal trespass charge. So due to the failures to appear, he's already got a $1,000 surety set, and stay away. We'd ask that it remain the same and stay away from 4430 Flat Shoals Road, which is the Texaco. A Texaco. Apologies, Your Honor.
Mm-hmm. All right. E.D. Bartels.
Yes, thank you, Judge. Mr. Mitchell has waived his appearance. I did send that waiver in. I'm advised that, well, it looks like he's 43 years old. I'm advised that he is self-employed. He has a music production company as well as he's a real estate agent. He was raised in Georgia. He's lived in Georgia ever since he was a young child, I'm told, and has extended family in the Atlanta area. So we would ask for a signature bond if he qualifies. If the court finds that he does not, then we would just ask that the $1,000 bond remain the same and nothing further.
Okay. With these cycles in the state, were you requesting to remain the same?
Yes, ma'am. $1,000 surety. Or yes, ma'am. $1,000 surety is already been set.
1,000 surety. All right, 1,000 surety. Stay away from the location.
Yes, ma'am.
No drugs, alcohol, weapons, or guns while on bond.
Apologies, Your Honor. I was answering something. And that location, do you need it again?
I don't know, Miss Holly.
I have it as 4430 Flat Shoals Road.
Yes, ma'am, in Union City.
Got it.
Thank you, my loves.
Mm-hmm.
All right.
Oh, I'm apologies. Thank you, Your Honor.
Next position for a waiver is position
20.
Position 20, Precious Montgomery.
Yes, that is my client, Your Honor.
Okay. And that is 26 CR 004966C. Criminal trespass pretrial.
Has a total of 14 cycles, 7 out of Georgia, 1 out of Tennessee, 6 out of Nebraska. Last arrest was in May of 2024 out of DeKalb for a probation violation. FTA from 2023, battery conviction 2023, theft by shoplifting conviction 2020, disorderly conduct convictions 2015 out of Tennessee, and then a 2017 out of Nebraska. Level 3 is pretrial recommendation.
Okay.
Yes, ma'am. On July 25th of this year, Officer Bozeman was dispatched to 609 Cascade Avenue Southwest in response to a known trespasser returning to the location. The caller advised that a Black female wearing a red shirt and black pants was trespassing and refused to leave. The officer said, let the report show that the caller, Mr. Herman, called 911 yesterday for the same female suspect who left the scene before police arrived. Mr. Herman stated that the suspect, later identified as Precious Montgomery, has trespassed from the property multiple times and earlier this week came to the property and stripped her clothes off in front of customers. Mr. Herman also stated Miss Montgomery even urinated within the property near the customers. Upon the officer's arrival, they saw the Black female suspect and immediately detained her. Miss Montgomery has been taken to diversion numerous times after previously trespassing, and the victim stated that he wanted to press charges. And due to her bizarre behavior and refusal to give a urine sample, she was denied to intake at Fulton County Jail and was transported to Grady Hospital for medical clearance. Once she was cleared, she was transported back to Fulton County and charged with criminal trespass. She has a $2,000 surety bond already set, and due to her trespass warning at the location, she'll need to stay away from China Cafeteria at 609 Cascade Avenue in Southwest. And we're asking for a social worker for MH or BHET.
Okay.
Yes, Your Honor. Miss Montgomery is 36 years old, and we do not have any objection to social worker visit. She needs housing resources and BHET, and I think it might be the best for her to be rescheduled for 11 a.m. so PD Paul Battels can represent her later on.
To put her what now, PB Kim? I didn't hear the end.
Competency
On
calendar.
the comp calendar,
Yes.
okay.
which will be scheduled for the 29th. I'm
Okay.
sorry, for the 13th of August.
8/13. Okay.
Mhm.
All right. Social worker visit 8/13. And was this was a preset bond again?
Yes, ma'am, at $2,000.
All right. So 2,000 surety. And I guess to stay away. It's got a lot going on here.
Yes, ma'am, a stay away from the Cascade location, 609 Cascade Avenue,
Right.
Southwest, and that's due to her criminal trespass warning.
All right. All right. No drugs, alcohol, weapons, or guns while I'm buying.
And Your Honor, Miss Bridgewater, I need to apologize for my earlier comment. I forgot myself for a moment. That was my bad.
Apology accepted on my end.
Right. Yeah, no worries. All right, that's it for this one for 20, right?
Yes, moving on to 27, position 27, Moses Thomas. Is this a waiver?
Actually, that one, he refused to come out, and we were not able to waive his appearance since he is not competent enough to waive his appearance. So I strongly believe that he should be reset for competency calendar at 11 a.m.
Well, does he have a bond?
Let's see.
Yeah, because if he doesn't have a bond, he still needs a first appearance.
And we need to have this case reset for Wednesday, Your Honor, because we were not able.
It sounds like it's a medical reset.
Yes, medical
Yeah.
Okay, so we'll reset him to July 29th.
Yes.
Okay.
Okay, and next how about position number 32, Jarvis Woodliff?
You still don't want to come?
Still don't want to come, okay.
Still don't want to come.
So are we gonna reset him to July 29th?
Oh, we can't keep resetting him. This is like his fourth reset. He's been in jail for 8
Okay, well,
days.
Judge, give me some sense of direction.
Could we do like we did for one of the other cases and take the camera to them? I know we did that, I believe, at
We
ACDC.
took the phone, yeah. And I told them I was giving them a bond and just kind of read everything.
Oh, was that you, Your Honor? I couldn't remember which judge had done it.
Yeah, I did it. Well, I think we've all done it.
Yeah, it's the routine.
That sounds like the best way to handle it.
Right.
Okay, so are we finna go upstairs and give it to him, or what are we gonna do?
As the deputy before he talks about us.
Officer Matthews.
Yeah, we won, but the signal's not really good on 2 South, so.
Hmm.
Your phone does not work here, Your Honor. Mine does.
What's wrong with the phones down there?
Really
I think
bad.
they
Oh, you know
use-
what? The last one I did was ACDC.
And I think that was
It
a
wasn't-
personal phone too. I don't think that was a professional phone or a work phone.
I don't know. I think it was her county phone. I thought it was.
a county phone that she used.
Yeah,
Okay.
it's a county phone.
So are we gonna try that?
So Deputy Matthews, you don't want to take your little personal phone? I'm messing with you now.
My first phone's in my car.
That's
Yeah.
right.
That's right.
So what can we do? Can he get to medical and then we talk to him there? Or y'all don't want to do that?
Well, I'll try to get on Wednesday. I'll definitely bring him out on Wednesday.
Wednesday's gonna probably be Riverside, isn't he?
I believe when there's a medical reset or behavioral reset.
Yeah, they don't go by that.
Okay.
That's my understanding.
All right. It was you promised to help us on Wednesday. Then I'll tell him you said you'll do it Wednesday. You'll do something
This
creative
is his
Wednesday.
fourth reset. He does have a $1,000 surety bond that's in place from the.
Oh, he does?
Yes, he does. He just haven't had a court appearance.
Right. Okay. Well, see what magic you can work for us for Wednesday.
Okay.
Okay. Cool.
Okay,
Is that it, Miss
I
Bridgewater?
believe so. With that being said, let's go over the calendar.
That's all I've got.
Yes.
Okay. So once again, the reset date for the SAP calendar is going to be August the 11th. Position number 1 is going to the SAP calendar with a $4,500 good bond. 2 is going to the SAP calendar with a total $5,000 good bond. 3 is being reset to Wednesday. 4 is reset further notice with a $3,500 SOB through pretrial. 5 is reset further notice with a $3,500 SOB through pretrial. 6 reset further notice with a total $5,000 SOB through pretrial. 7 is going to the SAP calendar with a $3,500 good bond. Position number 8 has a UJR and is reset till the SAP calendar August the 11th. 9 has a total $5,000 good bond with a 10% share of whatever you call it, and is reset for the SAP calendar. 10 is reset further notice with a $1,500 SOB through pretrial. 11 is reset further notice with a $600 SOB through the jail. 12 is reset further notice with a $1,500 SOB through the jail. 13 is reset further notice with a $2,500 SOB through the jail. 14 is reset further notice with a $2,500 SOB through pretrial. 15 reset further notice with a total $4,000 SOB through pretrial. 16 is going to the SAP calendar with a $1,000 good bond. 17 SAP calendar with a $1,000 good bond. 18 is reset further notice with a $3,000 total SOB through pretrial. 19 is going to the SAP calendar with a $1,000 good bond. 20 is going to the comp calendar on August 13th with a $2,000 good bond. 21 SAP calendar with a $1,500 good bond. 22 is being reset to Wednesday. 23 is going to the SAP calendar with a $2,000 good bond. 24 SAP calendar with a $2,500 good bond. There was a consent bond in position 25 with a $5,000 good bond. 26 has a consent bond with a $2,000 SOB through pretrial. 27 is reset to Wednesday. 28 is going to the SAP calendar with a total $2,000 good bond. 29 is going to the SAP calendar with a $2,000 good bond with a 10% through the sheriff's program. 30 is a plea, time served. 31 is going to the SAP calendar with the $5,000 good bond. And 32 is reset to Wednesday. Are there any questions, comments, or otherwise?
Yes, I had a question about position 8. I didn't hear the bond amount.
Position 8, I show it as a UJR, but I believe he has other cases, so therefore we're gonna set it to the SAP calendar.
Okay, and then for 31, you said $5,000 good, right?
31, $5,000 good bond is reset to August the 11th.
Thank you.
You're welcome. Are there any
Alrighty.
others? If not, let's sign off.
Good.
That's
All
it.
right,
Thank you, everybody.
Thank
Thank you, Judge. Thank you, everyone.
Right. You